President Roosevelt attended the dedication of this building in 1906, declaring this the handsomest state capitol I have ever seen. The architect of the building envisioned this to be a palace of art, and in no chamber was his vision as well embodied as in this courtroom. On this date, 96 years ago, May 23rd, 1927, the Supreme Court of Pennsylvania convened at 3:30 to unveil the majestic Violet Oakley murals that you see all around you in this courtroom. Ms. Oakley was selected by the Capitol architect, Alfred Houston, in the hopes that providing such an opportunity might inspire other women to pursue art. At the time, such a commission was a radical concept, and Violet Oakley was the first female artist to receive a large public commission. She proved up to the task. Already a well-regarded artist from Philadelphia, Oakley's work in this building made her world-renowned. Her vision for this room was to write a book on the evolution of law, and the murals in this room may remind you of the pages in a medieval or Renaissance manuscript. She began the work for this room in 1917 during the First World War. Upon its completion, Senator George Wharton Pepper remarked that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. I hope that while you're here in the Capitol, you'll have a chance to really look at these murals and appreciate this exquisite work of Violet Oakley. Before we hear the first case, I'd like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent, and please introduce your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues if they so desire. In cases in which there are multiple parties represented by separate counsel, please avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we're asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we want to explore further. While we have no set time limit for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, would you call the first case?
Commonwealth of Pennsylvania versus George J. Torsilieri, representing the Commonwealth, Mr. Ronald Eisenberg, representing Mr. Torsilieri, Mr. Aaron Marcus.
Morning. In this case, we're asked to determine whether the legislature's determination in Pennsylvania's Sexual Offender Registration and Notification Act, SORNA, that individuals who commit sexual offenses are at high risk of committing additional sexual offenses is unconstitutional because it employs an irrebuttable presumption that is not universally true. In addition, we are asked to determine whether the registration and notification requirements in subchapter H of SORNA are punitive. Please proceed.
May it please the court, Ronald Eisenberg and Tracy Pietkowski for the Commonwealth. When the court remanded this case previously, it did so for a very special kind of hearing, not the normal sort of evidentiary hearing. And it did that because the question is not one of judicial facts, but of legislative facts. The defendant argues that the facts on which the premises, the assumptions on which the legislature based the statute are simply untrue. And that is a much more difficult task than the normal burden in an evidentiary hearing. This court made it clear that the burden was a heavy one, quote unquote, that it would be the rare case where such a challenge to legislation could prevail, and that the defendant must show a consensus, quote unquote, that the legislative assumptions are wrong. It's the meaning of that word, I think, Your Honors, consensus, which is crucial to the resolution of this case. The lower court treated it as if it was essentially just a battle of experts, like the question of whether the defendant meets the insanity test or whether the DNA evidence can be sufficiently identified as a particular person. There were experts, 3 experts for the defense, 1 expert for the Commonwealth. The lower court said, I credit the defense experts. Her opinion never mentions the phrase heavy burden, never mentions clear as proof, never mentions rare, only mentions the word consensus once in relation to a punishment factor. And that's not how these sort of cases could be decided. The question here, whether the legislature adequately believed that there was a special risk from sexual offenders, is more akin to the question of whether the death penalty deters. That's a hotly debated question. I believe if I could gather every expert in the country who had an opinion about the death penalty and deterrence, most of them would say, no, it doesn't deter. There'd be a few on my side that would say it does, and hopefully they would be willing to testify to that. But that wouldn't resolve the question of whether there's a societal consensus about whether the death penalty deters. That's the kind of proceeding that we had here, and it's not adequate to use due process grounds to invalidate a statute. The question that the court asked for a consensus on was a precise one, not whether convicted sex offenders do or don't recidivate at high rates, whatever high rates might be, or low rates, whatever low might be, but whether they commit sex offenses more than non-sex offenders and therefore warrant special legislation, whether the legislature had a basis for treating them differently than other people.
Mr. Eisenberg, could you clarify, when we talk about recidivism here, are we talking about a sex offender repeating a crime of a sex offense or repeating criminal activity?
New sex offenses.
A robbery.
New sex offenses, Your Honor. And we're talking about the legislative assumption that sex offenders, convicted sex offenders, commit those crimes, that there's a higher risk that they will commit new sex offenses.
And not compared to other offenders such as a bank robber recidivizing with another bank robber.
That's right. The question is the risk of new sex offenses. So there's debate even outside of the realm of sex offenses about recidivism rates. I don't think anybody could truly claim that there's consensus about it.
But you have to be careful that we're not ever comparing apples and oranges when we're talking about recidivism.
Certainly not, Your Honor.
Many people look at it as, are you going to commit another crime? And
Right.
That's not what's before us.
It's sex offenses. And so the premise of the statute, and we'll get into the purposes, what the legislature wanted to do with this premise, but the premise of the statute is that there's a special risk for sex offenders. Now, the defendant...
Counsel, let's clarify that, because the legislature stated what their presumption was in the statute. Sexual offenders pose a high risk of committing additional sexual offenses. In your original brief before this court, you stated the presumption as sex offenders as a cohort pose a danger to the public due to their high risk of recidivism. So that's what we're talking about.
Yes, we certainly...
A high risk of recidivism. Isn't that the issue we're probing here?
Yes, Your Honor, with some caveats. Number one, what does high mean and who gets to decide? Now, I submit that is a classically policy-driven question.
Well, let's discuss that a little bit. I mean, The record in this case establishes that between conservatively 80 to 95% of sexual offenders will not recidivate. Who would say that that's...
That was the...
Who would say that 5 to 20% is a quote-unquote high risk?
I think
Isn't that the question?
I think 1 out of 5 would be considered quite high by many people. That would be considered a significant danger. And there are many legislative classifications where where perhaps even a smaller risk of any particular individual in the class committing an offense is considered sufficient to impose a restriction. Many people speed. Very few of them actually cause a crash by doing so.
Okay, well, let's probe what I think the predicate issue is, which is this irrebuttable presumption. Is it sufficient, and let's start with the lowest number, to create a irrebuttable presumption if only 5% of sexual offenders recidivate?
I don't think there's a factual answer to that question, Your Honor. I think that's a policy question.
Well, let's probe that too, because that confuses me a little bit. If there's no factual answer to any of these questions, then the legislature has no facts to support its irrebuttable presumption.
No, Your Honor. It's a question of what's known, okay? So even the defense says, well, we think it could be 5 to 20% that are recidivating. And the legislature gets to decide whether that's a sufficiently high risk to society that they should take action. And the nature of the risk, the level of the risk, is not just about how many people do it, but about what they're doing. So the risk that somebody's going to jaywalk and maybe get in the way of a car without anybody being hurt, there may be a lot of people who do that, but if it happens and a car has to stop, go a little slower, that's not a very high risk.
Well, and that's why you can't avoid the policy background of this in focusing on the dangerousness or potential dangerousness if there's a recidivism issue or likelihood of recidivism, and also the policy issue of the need to protect the public. This is a special area that the legislature focused on for protection of the public.
Yes.
How does that differ from other crimes?
It differs because of the nature of the crime. Does the legislature get to decide that sexual offenses are a particular danger to society in a way that most other crimes are not? That's a policy question. The legislature does get to decide that. But let's look beyond a bit at the claims about how many people recidivate. The fact that there's debate about that there's a lack of knowledge about that, or at least allegedly a lack of understanding, that doesn't go to the challenger. That goes to the legislature. The one body that gets to decide in the absence of clear proof that would satisfy a standard of law in a normal evidentiary proceeding is the legislature, because what's at stake here is not judicial facts, but legislative facts.
Well, and we cannot negate a legislative presumption except in very specific circumstances.
Yes,
so
Your Honor.
What are those circumstances that would allow us to negate it, and why isn't that? Why aren't those circumstances present here?
I think that the word consensus is really says it all, Your Honor. Consensus doesn't mean my side wins because the judge decides I'm more credible. Consensus means that it's really beyond reasonable debate. And in fact, that's the language the United States Supreme Court has used in the irrebuttable presumption cases. It said that the challenger has to show that the legislative facts could not reasonably be conceived to be true. And that happens sometimes. There are things that were done in the past that we have now, I think, come to a consensus on as not being appropriate. Everybody used to think that the best medical treatment was leeches. Even George Washington received that treatment. The richest people got the leeches. Much more recently, within my lifetime, it was common for surgeons to perform lobotomies on people. The man who developed that procedure, Dr. Moniz, actually received the Nobel Prize for it. And now nobody does. And if the legislature passed a statute that says we have to treat mental illness by performing lobotomies, I think there'd be a real problem there on due process grounds. But we have many other controversies in society, some of which are far more capable of truly scientific or data-driven resolution than this one, that are still quite controversial. The effect of masking, vaccines. There are science all over the place. There are a lot of scientists, maybe a majority who would take one side or the other. There are people who thought there was a consensus on this 2 years ago who don't now. The question is, which are we closer to, leeches and lobotomies or masking and vaccines? And I think it's the latter, because a consensus, as I say, means that the legislature couldn't reasonably have conceived it to be true that sex offenders present a special risk. Now,
Well, sex offenders, the statute doesn't say sex offenders present a special risk. It says sex offenders present a high risk.
Yes.
There could be other high-risk recidivism things, too. It's just the General Assembly hasn't acted on those.
And the legislature gets to decide which of those.
The General Assembly didn't say these are the highest risk. They said they're a high risk. So if I was to summarize your response to the Chief's question, it would be pretty much the General Assembly and the governor, because it is both branches, the executive and the legislature, that we would be overriding. The legislature, the General Assembly, and the governor would have had to engage in a flat earth society moment for us to do it.
Essentially, Your Honor. And as I say, I think that there have been consensuses reached, paradigm shifts, even since the discovery that the world is not flat. Much more recently than that, and so it's not out of bounds. But when it happens, you're probably going to know it. When you look at it, you're probably going to know
So it has to be an irrational presumption?
Yes, could not reasonably be conceived to be true. Now, the argument here is certainly not that there's no recidivism, not that there's no risk. The argument here is that 80 to 90%, that is 10 to 20% recommitting, that's not a significant risk. That's not very high. And as I say, that should be a legislative judgment, especially when considered what the basis for the claim is. And the basis for the claim is, well, we've measured the people who get rearrested. That's the basis for all of the claims about the level of recidivism. That's who we know. And from a criminal justice point of view, we can obviously only prosecute the people who get arrested. But the legislature could decide that they don't want to confine themselves to that class of people. That's where a phrase you might have seen in the papers comes in, the dark figure, which means unreported sexual offenses.
And in sexual offenses, there seems to be a higher incidence of non-reporting than in other types of crimes.
Your Honor, that is exactly my belief. It is not the belief of the defense. It is not the belief of the defense experts. But
They'll tell me why I'm wrong.
And they might. But here's an important point, Your Honor. They didn't actually say, contrary to the defendant's claim, that there is no dark figure, or even that they know what it is. On the contrary, in the Common Pleas Court judge's opinion at page 9, you'll see that she quotes the relevant statement from the defense expert that she relied on. We don't know how big that is. And because we don't know that number, we do know that the observed rates underestimate the true rates, but we don't know how much. We don't know by how much. That's the finding that the judge made, is that we don't and couldn't know the dark figure, the unreported level. And that's fine if we can't. But it doesn't preclude the legislature from making a judgment based on all the sources and political inputs that a legislature has.
Counsel, before you move on, let me get back to the irrebuttable presumption doctrine. The second prong of it is the presumption is not universally true. The presumption is not universally true. You would change that second prong to say the presumption is never true.
No, not at all, Your Honor.
Yes, you are. Because you're saying, we go from use leeches, and now we know that that's not the case. There are no situations in which you can override the policy decision, which I'm presuming is made upon facts. I mean, policy decisions are made on facts, correct?
That word fact is quite a slippery one, Your Honor.
Evidence, based on evidence.
Evidence and facts are very different things.
Okay, evidence. Okay, well, answer my question. Should the second prong of the rebuttable presumption doctrine say the presumption is never true.
No, and as you acknowledged in your dissent in the Torsilieri one, universal doesn't really mean universal.
I said if there were one deviation,
Well, if that were the
that would not trigger not universally true. But we're talking about a different dynamic here.
Yes, Your Honor. And if that were the due process standard for challenging a statute, the court would be very busy because almost every statute creates some kind of classification.
Well, what word would you use instead of, or words would you use instead of not universally true? What is the correct phrasing of that second prong?
I would say we are past that sort of pigeonholing in this sense, Your Honor. All of the defendant's claims depend on the same factual claims. All of his due process claims depend on the same factual claims about sex offender recidivism that we have been discussing. And that's why this court remanded instead of deciding any of those claims. None of those claims were ripe for decision when the case was last here, or the court would have been obligated to do so and not put everybody to the trouble of having to remand.
But counsel, that was because the Commonwealth didn't offer any evidence the first time around. That's why the claims weren't right the first time it was up.
If the standard is as is, I think your question presupposes, Your Honor, it wouldn't have mattered. It wouldn't have been necessary because it's perfectly obvious that in any classification there will be many people who don't fit in some way. Every legislative classification is to some extent over-inclusive and under-inclusive. That's why it's legislation. That's how it works. There is no other way to do it. And I'd like...
You may be right, counsel, but I'm struggling for writing an opinion that deals with this issue. And if we just regurgitated the words that you made from your podium today, we could not rely on the irrebuttable presumption doctrine as it's currently stated, because we could not say that the second prong is the presumption is not universally true. So tell me how we should rephrase that.
I'm just asking the court to apply the standards that it set forth in the previous case, the court standards, which were to prove a consensus. That's why I've been discussing that concept, because it's what the court, I think, properly demanded based on the United States Supreme Court precedent in order to prove an irrebuttable presumption.
Well, counsel, I'm looking at our precedent, Clayton, the PennDOT versus Clayton, 1996, which essentially was based on the presumption that if you have one epileptic seizure when you're driving, you were going to have another epileptic seizure. And this court said, no, you can't do that. That is not universally true. And we struck it down as unconstitutional. So what are we going to do that's different in this case?
I'm sorry, Your Honor. And there was no contention of that claim. There was no one on the other side saying, oh, no, they all are, or most are, or even many are, a danger because of the one epileptic seizure. The argument was simply, it doesn't matter, we get to do it anyway. And the court said that as a class, that's not true. I think I'm sure we'll get to it at some point anyway. I think JB is another example. What happened in JB? The court didn't decide that because there may be some juveniles, the rare juvenile, a few, whatever, that the classification was unconstitutional. There was a concession, a lack of opposition to the idea that in general, juveniles are different than adults. And the court relied on that, and importantly, said the court, it relied on a whole series of cases from the United States Supreme Court that also explicitly embodied the idea of consensus. We don't have that here. We have something very different. We have cases from the United States Supreme Court that say exactly the opposite, that there's evidence that there is a special risk of recidivism among sex offenders. In the Smith case, Smith versus Doe, and again in the Kebido case, the court acknowledged in that case that there's evidence on the other side too, but that the legislature gets to choose in that contest. Here, the recidivism rate depends in significant measure on the idea of the dark figure, on how much is unreported. As I've said, the defense evidence didn't prove that figure was non-existent or even low, whatever.
Counsel,
low
on that
means.
point, the defense didn't try to prove to the contrary. They agreed that there is a dark number.
Well,
But they also suggested, and I mean, tell me why this is right or wrong, that there's no reason to believe that statistically that dark number would be any less reflective than what the actual reporting is, which is 95% of sexual offenses are committed by first-time perpetrators. So why would the dark number underreported be different than what the actual reporting is?
I think the comparison, as we've discussed, is the risk of recidivism by sex offenders for committing new sexual offenses. And that's as compared to other people committing sexual offenses. And the presumption of the defense argument is, we don't have to care about the level of the unreported figure, whatever it might be, but the legislature gets to care, and the legislature, I would suggest, has cared in other contexts. So the premise is, of the dark figure, that sex crimes are special not just in the nature of the danger, not just in the level of the danger, but in the fact that it is particularly harder to report them than it is for many other classes of crimes. Murders leave bodies, shootings leave bullets, burglaries leave broken windows or doors. Sex offenses are usually committed in private, and the legislature could understandably believe that it is harder to come forth and report those. That's actually the basis for all the new statutes of limitations that have been extended by the legislature, say for child sex abuse. There's a presumption about child sex abuse and the difficulty of reporting it, the dark figure of child sex abuse that led to those statutes of limitations. And if this statute is unconstitutional because the legislature doesn't get to presume that there's a special risk of unreported sexual offenses, then those statutes are unconstitutional as well.
And there are significant studies that have not been challenged over the years about underreporting, particularly in child sex offenses.
Yes, Your Honor. And no doubt that these are matters of strong debate in society, just as the deterrence level of the death penalty. But the strength of those debates, I would suggest, is inversely related to the strength of a consensus showing. The reason there's a strong debate is precisely because there isn't a consensus.
Mr. Eisenberg, if I'm off on a tangent here, tell me, but one of the things I'm somewhat concerned about is that when we look at rates of recidivism and projecting the level of recidivism among sex offenders, it seems to me that those rates must vary pretty significantly based on the age of a sex offender. If a sex offender is convicted at age 22, his or her likelihood of recidivism must be higher than a sex offender that is arrested and convicted at age 75.
Yes, Your Honor. And perhaps another way of putting it, that point, is that the longer period you look, the more likely you are to find new, at least arrests for sex offenses, for discovered sex offenses. The shorter time you look, of course, the lower the recidivism rate's going to be. The defense experts were all over in terms of the studies they did, and it's about the length of time that they looked at.
And also just the significant factors of the age of the individual. I mean, a person in his 70s is not the same as a person in his 20s.
Absolutely, Your Honor. But again, there's a question of a special category here. In other words, was the legislature rationally permitted to believe that the falling off rate for sex offenses might be less than it is for other crimes? You take
What
some...
would they base that belief on?
That would be based on their common human experience, Your Honor. That what drives sex offenders may be different than what drives many other types of criminals, and that gang behavior, for example, that somebody takes part in when they're 15 or 20 years old, won't be as appealing to them when they're 50, but the drives that lead to sex offenses may well be as strong when the person is 20 as when they're 50.
Despite evidence to the contrary. So your view is, you may be right, that the legislature doesn't need any evidence. They rely on their gut instincts about how these things work in reality.
The legislature always has to do that, Your Honor, and there's
Do they have to rely on evidence?
There's-
Does there have to be evidence to support a presumption that the legislature draws? If the answer to that is no, then we're done.
There's always evidence, Your Honor. What there has to be is a consensus that the premises that the legislature relied on couldn't reasonably be conceived to be true. Of course there's evidence to the contrary.
Well, and then the more specific question in a case like this is, does Mr. Torsilieri meet the burden of proving, is it his burden to prove that the presumption was irrational?
Of course it's his burden, and the court put that burden on him and said, in fact, that it was a heavy burden, Your Honor. Now, there is a second question in this case. I've addressed due process because it's certainly the threshold question, but there's the question of punitiveness, of course, which the court has visited many times before, but I'd like to say that there's a difference here than there has been previously. In past cases, this was a really important question because of the ex post facto clause. In past cases, if the statute was found to be punitive, then it was certainly unconstitutional because it applied retroactively. Here we have a statute, subchapter H, that doesn't increase penalties on people retroactively, and therefore there's no ex post facto clause issue in this case. None is raised, none could be raised. So what I'd like to suggest is that the easiest way to resolve the punitiveness question in this case is not by going through the many Mendoza-Martinez factors, although I'll be happy to do that, but to go directly to the substantive constitutional claims that are based on the premise of punitiveness. Punitiveness in and of itself is not a constitutional error. The first of those, Your Honor, is the A.L.R claim. The defense says that the type and date of the offense are necessary to classify it, to know whether it falls under subchapter H, and that a jury had to find that fact. And the simple answer to that, Your Honor, is that the same is true for any statute. Every statute, criminal statute, has an effective date, and the defendant, it can't be applied to a defendant whose crime occurred before the effective date. We always have to decide that, essentially in every case, which criminal statute applies based on the date of offense. The same is true for the statute of limitations applicable to that offense. Juries do not decide that question, Your Honor. That is not a jury fact. It's not an element of the crime. No A.L.R problem. The next claim is separation of powers. The defense claim is that only judges can make any of the factual decisions that affect the quote-unquote sentence imposed by subchapter H. But in fact, that's what happens with all sentences. This statute here in section 23 of subchapter H says that the court shall classify the offense at the time of sentencing. It's the court that does that at the time of sentencing. And that at the time of sentencing, the court shall require the individual, this is section 19, to immediately report to the Office of Probation and Parole serving that county to register. That's how sentences often work. What happens after that? The defendant goes off to prison, and what does the Department of Corrections do during the course of his time there? The Department of Corrections decides, given the sentence that's been imposed by the judge, whether it's been served. They have a whole unit that does sentence calculations. What day is today? How many days has he been in? What does he get credit for? All of those decisions are made by an administrative agency, all subject to judicial review, just as any of the determinations made by the Pennsylvania State Police in relation to Megan's Law. All of those things can be appealed and often are appealed to Commonwealth Court. There's no separation of powers issue in that, and in fact, the court has long held that, going back to the case of Young versus Board of Pardons in 1979. The court quotes exactly the same language that the defendant does in his brief, from subtly about sentencing being judicial function, no fragment of the sentence can be decided by anybody other than the judge, and the court dismisses those arguments for separation of powers purposes. The only other claim based on punitiveness is that lifetime registration under subchapter H is cruel and unusual punishment. First of all, most of the registrants under subchapter H aren't serving life. Life registrants under subchapter H are only about 15% of the people on the Pennsylvania registry. But more important, the argument has been all along, for punitiveness purposes, that life registration is akin to life probation or parole. Life probation and parole are not cruel and unusual punishment. And life registration is no more cruel and unusual punishment than lifetime on parole. I'm sure the defendant will try to make distinctions between the two. Many of those distinctions in reality cut the other way in ways that make a lifetime on parole more restrictive than lifetime registration. Now, I said I would touch briefly on the factors, the Mendoza factors, although I don't think that they need to be dispositive. There are many of them, and really, the process can be simplified by going directly to the defendant's substantive claims, which are far different here, as I said, because there is an ex post facto issue. But it is worth noting that this court has, in case after case, addressed concern with two particular aspects of the registration scheme: lifetime registration and the absence of any removal provision, and also the in-person reporting. Those are exactly the concerns that the legislature addressed. Those are the differences between Subchapter H and the prior law. In the prior law, lifetime registration required, 25-year registration required, I believe, 100 in-person visits. Now, after 3 years, those visits can be done telephonically, so that the number for Tier 1, the lowest tier, is, I think, 28 visits, as compared under Subchapter I, which this court approved in Lacombe, of 25 visits over 25 years. So almost the same in terms of in-person visits to what the court approved of in Lacombe. And the registration, the removal provision after 25 years is also new. Now, the defendant says we can't report telephonically because the department doesn't have a telephone system. Number one, I've been advised by the department that that system will be published as required in the Pennsylvania Bulletin perhaps within the next week to month, and then will be operational. Number two, what I think that fact demonstrates, is that the statute has to be based on its terms, not on how it's applied. If somebody had wanted to sue the department to mandamus them to put the telephone system into operation earlier, they could have, but it's not a basis for finding that the statute is unconstitutional on its face, as they claim. And the removal provision, which the defendant says doesn't really count, and his expert says, no, doesn't really work. Well, again, it was their burden, as the court said, specifically by clearest proof to show that, and they didn't. The 25-year provision puts lifetime registrants potentially in the same position as 25-year residents, and therefore addresses the court's previous concerns. There are, as I said, many factors, but in the end it's a balancing for the court, and that balancing is not a quantitative one, and I think that those changes are sufficient to distinguish this case from the prior cases and to make it more like Lacombe. But in any case, and I think more importantly, there would be no substantive constitutional errors even if the statute were deemed punitive.
Counsel, before you sit down, let me go back to a question I asked you earlier, because I truly am struggling with this. Second prong of the irrebuttable presumption doctrine, as we stated, the presumption is not universally true. Your argument you can't win if that is in fact the correct statement of the second prong of the irrebuttable presumption doctrine. I'm going to ask you again. What is the correct measurement of the truth of the presumption that is being made? It's clear, not universally true is not what your argument is, because, just for the sake of discussion here, as I read your expert, he's not actually quibbling with the fact that 80 to 95% don't recidivate, give or take. Okay, so clearly, if 80 to 95% don't recidivate, then the presumption that they recidivate at a high rate is not true. So what is the measurement? How do we restate this second prong of the irrebuttable presumption doctrine?
If the word universal were taken virtually liberty and in isolation from everything else about this Court's and the United States Supreme Court's case law.
How about our case law?
Then, that's what I said,
really
this
hung up on our-
Court's and the United States Supreme Court's case law, then there'd be a problem, but it wouldn't be confined to this statute. It would be a problem for virtually every statute. I'm not sure there's any statute for which it could be said that the legislative classification is universally
But what's different in this statute is that it triggers the first prong because the presumption impacts an interest protected by our Constitution, the right to reputation. And you know, that impact on a fundamental right is not at play in every statute. That's the only reason we're looking at the irrebuttable presumption doctrine here. It's because of the right to reputation.
It's at play in many statutes, Your Honor, and we've cited the Gondelman case decided by this Court addressing the classification of, this is before recent constitutional amendments, the classification of judges by age. And the statute required judges, or perhaps it was the state constitutional provision, I'm sorry, I don't remember.
It was the state constitution, but age discrimination or a classification based on age is not a fundamental right in Pennsylvania.
Well,
reputation is.
Number one, Your Honor, the meaning of the classification, and to argue it exactly as the defendant has argued it here, is that those judges over the age were deemed not mentally fit to perform their functions. And those judges actually argued to this Court. That's degrading that classification.
Yeah, but that same argument was made again in Driscoll, and former Chief Justice Saylor wrote the Driscoll opinion and honed in, appropriately so, on the fact that what the judges were arguing did not trigger a fundamental right in Pennsylvania. So here, straight on, we have a fundamental right. One of your arguments that intrigues me more is, and I'd like you to talk about it a little bit, is the potential impact that a ruling in this case will have on those crimes that prohibit convicted defendants of carrying firearms.
Yes, Your Honor.
Now, that is a fundamental right, and so I'm interested in your read on that.
It clearly is a fundamental right of reputation. There's actually, I'm not aware of any right in the Constitution or in Article I of our Constitution to which more words are applied, and it was given its own section than the right to bear arms. So if reputation is a quote-unquote fundamental right, it certainly seems that the right to bear arms would be, and therefore all of the defendant's claims in this case would apply to any legislation affecting the right to bear arms, most specifically to legislation that prohibits former convicts from owning guns. Now, the implication, as the defendant would put it, is that all of those former convicts, people who have been convicted, like sex offenders here who have been convicted, are too dangerous to own a gun, when in reality, of course, that supposition is not universally true. There are many people in that class who would not be too dangerous to own a gun.
How do you know that? I mean, and like, as I said, I mean, I think this argument is an important and impactful argument in terms of the ultimate outcome of this case, because we've not yet had a challenge to one of those statutes that takes away the right to bear arms.
And a similar challenge in that context, if this challenge were approved, would be for any challenger to get together his experts, his chosen group of experts, and find the judge who he thought was most likely to rule in his favor. There are 60 judicial districts in this Commonwealth. There are over 400 common pleas judges. Presumably, more than one challenger could go to different places and put on their hearings, and presumably some of those judges will come to directly opposite conclusions. If those conclusions were factual findings that are binding on this court, then the court would be bound both by the factual findings in favor of and the factual findings against, which would be, I think, absurd. That's where we get back to where we started with the word consensus. That's why the court required it. It means something more than what the defendant is claiming here.
Mr. Eisenberg, I think we understand your position. Do any of the justices have further questions? All right, let's hear from Mr. Marcus. Thank you.
Good morning, Your Honors. Madam Chief Justice, and may it please the Court. Aaron Marcus from the Defender Association of Philadelphia, along with my colleagues, Marnie Snyder of Counsel, and Emily Mursky from the Delaware County Public Defender's Office on behalf of Appellee Mr. Torsilieri. Your Honors, SORNA falsely labels Mr. Torsilieri and thousands of others like him, convicted of a wide array of crimes, as high-risk sexual dangers, often for the rest of their lives. It then continuously broadcasts that label to the public well into the future, despite no reasonable debate, consensus evidence, as proved to and found by the trial court below and even 3 years ago by Judge Sarcione, that one, many, if not most people on the registry pose no special risk, no added risk, no different risk than other people not on the registry of sexual recidivism, certainly not a high one. That SORNA does not protect us from the harm of sexual recidivism, that it's ineffective, that we can and do identify the relatively few people who do pose that elevated risk and are skewing the average that the Commonwealth relies on. And that more effective alternative means exist to both identify those individuals who do pose that elevated risk and alternative means to effectuate protecting the public from sexual recidivism.
But even though you and we might be able to think of better ways to do it, this was the way the legislature and the executive agreed to do it, and how is that irrational?
Well, so there's two questions before this court, right? This court remanded one for whether all registrants pose a high risk of sexual recidivism, which is relevant to the irrebuttable presumption claim. And then we also raised our substantive claim under the reputation provision, Article 1, Section 1, Article 1, Section 11. And that is a question of whether there are other effective measures in order to achieve the legislative end. And that, when there is a fundamental right at issue, requires an assessment under strict scrutiny.
Isn't the right of reputation already affected by reason of the conviction of one of these offenses?
Certainly the conviction will affect reputation. There is no question about that. But the message and the declaration that is presented by SORNA is fundamentally different than a record of conviction alone, which was discussed at length, not only at the hearing below, but in multiple expert reports, that there is a difference between the conviction and the effect of the registry's label of a high risk of danger on individuals, particularly things like unemployment, joblessness, houselessness, things like depression and even suicide are affected by the label that a person, not just what they did in the past, but who they are now and into the future. What SORNA says is that individuals on this registry pose not just at the time of the conviction, but now and forever into the future, as long as they are on the registry, a high risk of sexual danger.
And if counsel, we disallow that on constitutional grounds, what is the principal stopping point that would prevent petitioners from coming in here and challenging any number of other legislative classifications, including the prohibition on the right to bear arms that was raised with Counsel Eisenberg a moment ago?
Sure. There's a couple questions, I think, in that. The first is, right, what is potentially the constitutional parameters around SORNA itself to stop claims if this court were to agree with ours here? And I think what the standards or tests require under strict scrutiny or the irrebuttable presumption is essentially a shorter, a private, and an individualized registry. Those features, consistent somewhat with an example of an option like the model penal codes, would be arguably more likely to be constitutional.
So that I think I heard you say then that with respect to the prohibition on felon access to firearms, you would suggest that were we to affirm this here, that the current ban on access to firearms for felons would be infirm and would need to be amended to allow individualized hearings in those cases?
No, not at all. I actually think that argument is really missing the point for a couple reasons. Number one, Gondelman is even a good example that one constitutional provision under state law does not allow us to subjugate it by another constitutional provision. The Constitution can be effective. But more importantly for the firearms principle, the Second Amendment by the United States Constitution after Bruin has its very clear own test, which requires that it can only be infringed if history and tradition demonstrate that such a restriction was appropriate. Number two, that is a very different test than what we're applying with reputation clause. Second, a state constitutional provision cannot undermine a federal substantive right that's constitutionally based. We can't apply Pennsylvania's reputation to undermine a federal constitutional provision. That is the federal supremacy clause that governs over a state constitutional provision.
How does that play into the restriction on firearms, the right to reputation? You're mixing apples with oranges.
I don't believe our reputational claim would be applicable to a Second Amendment challenge.
It wouldn't, but it would be a analogous argument regarding the restriction on firearms. The argument would be all people who commit X crime for which their gun rights are taken away will not use a gun again.
I think the analogy is apt. Its legal applicability is not consistent.
Counsel, you're aware that the Pennsylvania Constitution includes a right to bear arms, that it provides much greater protection than the Second Amendment.
Absolutely. And again,
So your idea that we would be engrafting state constitutional law on the Second Amendment, that's a non-starter. The question is, the right to reputation is as ingrained as a fundamental right in the Pennsylvania Constitution as the right to bear arms. Why isn't it the same? Why isn't whatever we do here, as Justice Weck put to you, demand the same result if someone would challenge the felony bar rule? And the remedy being an individualized assessment.
Because it's the same idea that I think this court discussed in Gondelman, which is that once you have two arguably competing constitutional provisions, one is not allowed to usurp the other. They are going to be different applications and different tests. The irrebuttable presumption doctrine focuses on legislative determinations, not constitutional.
The General Assembly made a legislative determination that convicted felons should forfeit their right under Article 1, Section 21 of the Pennsylvania Constitution, presumably because of some danger that these felons pose to the possession of a firearm. How is that not challengeable under the framework that you're advocating in this case?
The legislation would be subject, I believe, it arguably would be subject to challenge. The difference is whether the constitutional provision and what it protects with an individual's right to bear arms in Pennsylvania is not subject to an irrebuttable presumption challenge. The legislation is, but this court will need to make a determination at some point, and I am not equipped to make that.
I'm still not sure I understand your point.
So
you have the felony bar statute, and you have SORNA. The argument is SORNA is unconstitutional because it creates an irrebuttable presumption. The argument would be that the felony bar statute is unconstitutional because it creates an irrebuttable presumption. Where am I missing this?
So there's only one right at issue in this case, which is the right to reputation. There are two rights at issue in the firearms case under Pennsylvania's Constitution. One of those rights is the right to bear arms as presented and explained by Pennsylvania's Supreme Court, this court, as being broader. In that respect—
What's the other one? What's the other right?
I'm sorry?
What's the other right? You said there's two rights.
Arguably, it would be a right to reputation, too, because once you're branded a felon, you're branded to be potentially dangerous and incapable of exercising your Article I, Section 21 rights.
Yes. Right? The legislature is allowed or is capable of making that determination, and it could be subject to a reputational challenge. But this court must first determine what is within the protected interest. Is the protected interest the right of individuals possessing the right of convicted individuals to possess firearms protected by Pennsylvania's Constitution? If it is not, then and let me step back for a minute. Even under federal application after Bruin, we look at first whether these interests at issue are even protected, right? Is it within the history and tradition to be protected by the Second Amendment? Similarly, I would imagine this court would look at whether the restriction at issue is protected.
But the point that's being probed here, I think, implicates the question of, if you prevail here, where does this process end? Because the General Assembly makes classifications and class-based cohort judgments all the time. And if we're going to get into the line-drawing business, I suppose there are any number of statutes and pardons that touch upon people's reputations. Why is your case special?
Well, so several reasons. One, and I'm not going to comment on what proof there may be about reputational impairments about felon in possession statutes. There may be a significant hurdle for individuals to raise actual and factual reputational harm to somebody who is banned because of a prior conviction. There is no, in that case, a similar message that is presented to the public about somebody who necessarily has a prior conviction.
They aren't on a registry, for example.
Exactly. They are not on a registry, and they are not declared to every single individual who uses that registry of a clear and present danger.
So under our Constitution, the question would be regarding the right to bear arms, whether under strict scrutiny there are less intrusive means of handling the issue of purported dangerousness.
Yes, and that is especially if we're looking at the substantive, the reputation claim itself, not the irrebuttable presumption claim. Both are—
Let me ask you this question. Did your testimony establish a consensus on the issue of whether all sex offenders pose a high risk of reoffending sexually?
Yes, absolutely.
Did anybody ever say that? This is a consensus.
Every single one of our experts said that in both their reports and in testimony. That the issue here is not whether there is an average at the time of conviction. The issue is whether all people who are subject to this presumption pose a high risk of sexual recidivism. And the graph on page 18 and Carl Hansen's testimony, which was accepted by the court. J.J. Prescott testified as well as all of his expert evidence that was admitted into evidence as his testimony in the appendix to his expert report was not rebutted. The reality is that the overwhelming majority of people on the registry pose no different risk than anyone else not on the registry.
Assuming that's true, what is the principled standard that we articulate to give our imprimatur to a consensus? I mean, when Galileo spoke, he spoke against the consensus. I think he had some bad consequences for that. And I guess I'm interested in hearing from you what we tell the public and put into the law of Pennsylvania as to when scientific or evidentiary standards rise so high that we pronounce them the consensus, and whether we've, in doing so, put ourselves at risk of waking up the next day and finding out that it's not the consensus?
Well, so what I think is the right approach is the no reasonable debate. That doesn't mean not any debate. It means no reasonable debate. And that is true here. We're not in the lobotomy and leeches versus masking scenario. A consensus is more in line, Justice Wecht, with, frankly, sort of human-caused climate change. Would be a reasonable argument that if evidence were presented, it is possible that would be proven by consensus. I don't know if it is or is not. I'm not presenting evidence on that. But that is more in the field in which the experts in that community, who work in that area, who study in that area, who write in that area and publish in that area, if they all overwhelmingly have an agreement as to a particular outcome, and the only opposition to that is either one or two persons' opinion or an outlier piece, a single outlier study that is not accepted as representative, then that's going to be consensus. And that's what we have here. We have study after study by numerous experts, numerous people working in these fields, coming to the same conclusions over and over again, which are accepted across the various disciplines involved in researching sex offense recidivism, in researching registries and notification. All of those people doing that work have agreed. Professor Letourneau said, I can't think of one person who's doing work in this field who disagrees with that position.
Well, but I'm trying to understand too, because I think this court overriding the General Assembly and the governor and coming up with some standard that can establish when we will even entertain that is a monumental challenge. And I'm trying to understand this idea that we're not sticking to what the text that the General Assembly wrote was. All the General Assembly wrote was that these particular offenders have a high risk of recidivism. They didn't say the highest. They didn't even define what high was. It seems to me that, I think whether something is at high risk of recidivism depends on what the crime is, and also is an evaluation not of whether an offender actually does recidivate, but whether they're at high risk to recidivate, much like an alcoholic is at risk of having a drink. But not all of them do. But that doesn't mean they weren't at risk for it. So the idea that you're analyzing statistics of how many sex offenders recidivate isn't really what the General Assembly was saying. The General Assembly wasn't saying all of these offenders recidivate. They said they all have a high risk of recidivating. Why are we focusing on recidivation rates as opposed to whether an individual, even if they never recidivate, was at high risk for recidivating?
I agree with you that the definition of high versus low is amorphous. That is a problem. What we are looking at is relative risks, because you need a baseline to make a determination of high versus low. The baseline that this court remanded to consider is people not on the registry and people who are on the registry. And what we see is that the overwhelming number of people, and this was proven and accepted by the court below, who are on the registry pose no different risk to recidivize than people not on the registry but have otherwise been convicted of various crimes, the robber, the burglar, the domestic abuser. The issue is when we are—
The General Assembly could have easily, again, I'm not sure that, and I wasn't, with all due respect to my colleagues who were involved in Torsilieri, I got to watch from the gallery. That wasn't what the General Assembly said, though. The General Assembly didn't say these offenders pose a higher risk than other offenders do. The General Assembly basically said these offenders pose a high risk, and we believe that the public deserves added protection because of the nature of the crime. It's like, SUV, and why shouldn't that be the analysis, which is simply, was the General Assembly's judgment that whatever that risk is for that individual, again, not that they will, but that risk is, in our view, as a General Assembly, high. And therefore, we're going to create this special legislation to protect the public because of that high risk and the nature of the offenses.
Because as we showed and was accepted by the court below, most of the people who are on the registry do not pose any elevated risk beyond anything else. We're talking about below 2% chance, which is essentially the population.
I thought it was 1 in 5.
No. So those are different issues. The question about the 80 to 95% will not reoffend, right, is the fact about everybody convicted of a sexual offense at some point in the future will 80 to 95% will not reoffend. So there's a 5 to 20% of those individuals will. So 1 in 5 might. In the course over time, but that is determined based on the moment of the sexual conviction. The registry isn't about that. The registry is about a current and present danger, and that's what the legislature is saying, that every single person on the registry now, then, and in the future, as long as they are on the registry, poses this, quote, high risk. Now, what our experts showed and the agreement, consensus in that research community, the academic community, is that people who are initially convicted are not all alike. They are various risks to begin with. Some people are, quote, above average, 30, 40%, but that's a relatively few percentage. Some people pose no risk beyond anyone else at the moment of their conviction. And we can easily and readily identify risk differentiations in these pools. We even do that right now. I mean, Pennsylvania's SVP assessment is a determination that looks at whether people are, because of a mental abnormality or disability, are likely to engage in predatory behavior in the future. This is about a future risk determination, and that's what the SVP assessment is designed primarily to do. I'm not going to concede that the SVP assessment is a measure of perfection at all. However, it is a measure that this court even put forth in JB to look at alternatives to assess risk potential, which we talked about.
Can I ask you a question on JB, counsel? Why should this court continue invoking this irrebuttable presumption doctrine at all, given that SCOTUS hasn't done so since the 1970s, so far as I can tell? Is this sort of akin to our continuation of Lochner, even though SCOTUS has abandoned Lochner many decades ago? Why are we using the irrebuttable presumption doctrine invented by SCOTUS when SCOTUS itself abandoned it? And why aren't we just using equal protection and procedural due process and appropriate classifications under those doctrines?
Well, I would submit that there was a reason why we presented to this court as the first issue in our briefing the substantive claim, which has a wide and long history of acceptance both in this court and the U.S. Supreme Court when strict scrutiny is applicable to fundamental rights. That is a separate and distinct claim from the irrebuttable presumption doctrine. So I would suggest that these are two separate and distinct arguments that we make, and they are assessed under different standards. The irrebuttable presumption claim, however, I do think is important when fundamental rights are at issue because it addresses something different than the substantive reputation claim under strict scrutiny. While both assess the question of when and whether the legislature can make over-inclusive judgments, the irrebuttable presumption looks exclusively at that initial determination of class and whether the people within that classification are representative of the presumption at issue. Plain and simple. It doesn't have a question of effectiveness. It doesn't look for narrowly tailoring on other effectiveness issues. It's purely this legislative determination of how broadly it may define a class. And this court has said Muniz is an example, and in other cases in Schul, that society has an interest in making sure legislative classifications are not overbroad and over-inclusive. And that is extraordinarily important. Justice Doherty and Muniz, I believe that is a quote from the excessiveness prong in looking at whether the legislation is excessive in relation to its purpose. This court, rightly so, has to have some measures to check legislative over-inclusive classifications. Now, for the irrebuttable presumption claim, when fundamental rights are at issue, that's a significant concern. Sometimes the analyses will be overlapping in a substantive claim regarding whether strict scrutiny is narrowly tailored. I would submit that on the strict scrutiny assessment, which the Commonwealth hasn't challenged, is ignored completely in this brief, and has accepted that even at worst, intermediate scrutiny applies. But the purpose is, and this court has said, fundamental right goes back centuries, get strict scrutiny, no question. You look at the compelling interest protecting society from recidivist sexual offenses. No question compelling. Absolutely compelling.
Counsel, can we go back to this, just the question of utilizing the irrebuttable presumption doctrine? I mean, none of the argument we've heard today in any way, shape, or form actually fits within the contours of that doctrine as we stated, particularly the second premise, which is the presumption is not universally true. Nobody talks in those terms. Okay, so we have a little bit of an issue with that to begin with. But the doctrine itself seems to collapse the substantive analysis under strict scrutiny and less intrusive means with the irrebuttable presumption doctrine. Because as you read the irrebuttable presumption doctrine, you don't get to the existence of a reasonable alternative unless you found that the presumption is not universally true. What you're arguing is that there are two different arguments entirely. One is the irrebuttable presumption, which indeed includes that third prong that's premised on the existence of a presumption that's not universally true. But secondly, the first analysis that you would direct us to is pure strict scrutiny. Is there a compelling state interest? I think we would probably say yes. The next question is, are there less intrusive means to effectuate that goal? That's the analysis that you would want us to do, and you'd want us to look to the testimony of your experts that indicate the alternative means that are available.
I think that is a precise and clean argument for this court and a clean analysis, especially because we have established all of the facts that are necessary to demonstrate that less intrusive means are not being taken because the class at issue, one, is significantly overbroad, and there are many other ways that could be more effective in reducing recidivism when SORNA fundamentally fails to do so.
Let me just complete your thought on this,
Sure.
or help my thinking on this. Assume you go through the analysis using something like the SOAB board, something of that akin to that does an analysis of sexual offenders. If they are found to be an individual who is likely to recidivate, then they would go on a registry. You don't have a problem with that. If they are found to be likely to recidivate going through this process, then the registry is okay with you.
It depends on the form and function of the registry. As I said, like the current version of the registry, number one, so if they were found likely to recidivate, right, at the time of the initial assessment, is a 25-year or lifetime registry appropriate or constitutionally sound? The evidence is very well established in the record here that there is no basis to include individuals who have not reoffended on the registry for 25 years or
How
life.
about those individuals who haven't committed a sex crime?
I mean, certainly that would also be a problem.
Yeah. Well, do we get to that in this case or not? I mean, we addressed it in Muniz, and then the legislature took out some of the non-sexually based offenses that were included, but we still include kidnapping and interference with the custody of a child, which are not sex-based crimes. Is that in this case or not?
I mean, it is in this case.
But how? Because
Well,
your
it's-
client's not
sure,
convicted
it's-
of either any of those things.
It's in this case in a number of capacities, certainly on the narrowly tailoring prong. It does not make sense to be narrowly tailored when you include offenses that don't have any sexual component. Number two, right, it's applicable in the Mendoza-Martinez assessment where we looked at it before. Right? But even so there are applications where that is clearly relevant and demonstrates over-inclusivity and not narrow tailoring. But again, I think I would like to also respond to your question, Justice Donahue, about the universality principle of the irrebuttable presumption doctrine, because that is the second prong. And if reputation is established as a fundamental right and established as harmed, you look at whether the presumption is universally true. And that universal application, looking at Clayton and J.B., and Flandis and Stanley, all of these cases rely on legislative or congressional determinations that presume particular higher risks as classes. Right? The class of people fits a particular high risk or a particular higher concern. The question for universality is whether all the people within that class are reflective of that concern. And here they are not, by widely over-inclusive margins. Most of the people at any point on the registry do not reflect any elevated risk of recidivism from anyone else who has ever been convicted of a crime. They are not high risk. Those determinations are 2% or under.
But that's based on statistics of how many recidivate, which is a different question from at what risk are they of recidivating.
So it's a question of what risk versus, and you always have to determine risk based on observed result. That is always going to be the case. That's how.
Well, that's what we're arguing in a court of law, but that may not be how the General Assembly saw it.
I mean, that's the only empirical way to assess risk. And what we've shown is that most, if not many, if not most of the people on the registry at any one time pose a 2% risk or under of committing a future offense.
How do we wade into empirical assessments of risk here and avoid doing it in other cases? Or put differently, if the argument here in part is that this impairs the right to reputation, then how does that argument not extend to this ban on felon possession of firearms impairs the right to bear arms, or this incarceration impairs the right to liberty, or this custody decision impairs the right to raise one's children? So these are all, fundamental rights, but it's well established that the state can invade these areas upon proper determinations. And I don't know what your argument is as to why your case is special and why there isn't a slippery slope problem here.
Well, in a number of those instances, you are not dealing with a primary legislative presumption of risk. There are different presumptions at issue. In the instance of particular sanctions or punishment, it may be the presumption is that we need to deter. It is the presumption that people need to be punished or sanctioned, not based on risk, but for other purposes. So there could be different potentials there. For the firearm application, again, I don't want to litigate that issue before this court, and I don't know if the presumption in a felon in possession is that the person is necessarily dangerous, as opposed to other reasons why felons should not possess firearms, such as they may transfer guns to others who are dangerous, that we do not want individuals with, well, also for a state statute, that it may violate federal law, that they don't want individuals who have felons in possession who may be less reliable or responsible, having guns in or around their home or other people. There's lots of reasons.
But you would invite a courtroom proceeding in a chosen 60 judicial district Commonwealth for the evaluation of evidence about whether a convicted felon has a high risk or likely, I think you used the word likely, to transfer a gun illegally. You would invite that But I don't think that's really my question anyway. But I did have I wanted to get to one area that we haven't touched upon yet. Let's say I'm struck by the fact that this is a facial challenge, a facial constitutional challenge. Why isn't it at least somewhat more palatable to allow these challenges to happen on an as-applied basis, similar to how the Superior Court disposed of Muhammad, and allow constitutionally for an individual who is going to go on the registry either right before they go on the registry, after their term of incarceration is over, or at sentencing, either. I don't think we've said which one you have to do, and allow that person to come forward with evidence to convince the judge that they shouldn't, that they do not pose a risk. This was a one-off situation. The facts don't justify this. The score was 0 on their recidivism study. Why isn't that better, or at least more incremental, than this court just blowing up the statute, which I think it seems to be what you want us to do?
Well, for a number of reasons. And one, the idea of having a post-deprivation opportunity to then rebut the essentially procedure by presumption that denies a fundamental right is not meaningful and not consistent with this court's prior case law. So in the irrebuttable presumption doctrine, it's been very clear that pre-deprivation constitutional determinations must be made in order to assure that fundamental rights are not being deprived of individuals based on what is essentially a procedure by presumption. Now, at that hearing, if there was at that hearing in which, for instance, in this case, SORNA were imposed, right now there's no hearing in which SORNA is imposed. The only hearing that exists is for SVP assessments. There's not a hearing. If there was a hearing to make a determination about a person is at risk, then that would be individualized and sufficient. The question of who bears the burden, is there a rebuttable aspect? That hasn't been decided by the legislature, and it hasn't been decided by the court.
But the remedy to a due process violation, the violation of your right to reputation without due process, is to afford due process, not necessarily to strike the statute.
Well, but if right now what this court would have to do is then rewrite the statute to allow a process to occur, which is not...
Respectfully, I disagree with you. I think we have seen in cases that this court has issued dealing with the right to employment in care facilities, where the Commonwealth Court now will give a hearing to someone who has barred from being employed by these care facilities when the statute says that they are barred, to give them an opportunity to prove that they are not at risk and can have employment. The fundamental right to pursue your employment is a fundamental right in the Pennsylvania Constitution.
So, in order to deny the fundamental right initially, having a hearing where that issue is in play would need to be provided individualized. I think that is what this court's...
Which is what happened in Muhammad.
Yes. Well, but there is a difference between the Muhammad application, which doesn't provide you an opportunity to present it at the initial determination and forever, and also, more importantly, it's not meaningful in any way, Justice Brobson. The run as a civil matter, there's no right to counsel to SORNA determinations at all. That subsequent, whether a person does not pose a risk 1, 2, 3 years, no right to counsel. It is incredibly difficult and expensive to make those determinations. It is not a meaningful assessment. For instance, the 25-year registry provision that allows for removal under SORNA says expressly that the individual has to prove that they are no longer a risk. That proof requires expert evidence. It probably requires counsel. That is not meaningful in any real way when you have a fundamental right at issue. If it happened at the time of a hearing, I'm sorry, Your Honor.
Let's assume that's onerous. Let's assume, for the sake of argument, that any one of us or group of us might find it silly or unreasonable or heavy-handed or unwise, etc. Why isn't it the case that some impairment of the unvarnished right to reputation is a collateral consequence of the underlying criminal conviction, which was established by proof beyond a reasonable doubt. Why is the legislature not allowed to take into account in creating this policy, which may be unwise, but it gets to do it, I suppose? Why are they not allowed to regard some damage to that previously unvarnished reputation riding along with the criminal conviction of this crime they've judged heinous?
Well, I think they are. It's just a question of what it is they impose based on that.
But counsel, doesn't that impact the level of scrutiny that's applied? I mean, you aren't dealing with someone with a sterling reputation to begin with. I mean, an argument can be made under those circumstances that strict scrutiny may not be the appropriate level of inquiry in terms of the means selected.
I don't believe that's right. I think regardless of where a person's reputation precedes that determination, whatever that level of reputation is in the community, that's fundamentally distinct from whether the legislative determination has an impact beyond what previously occurred on that reputational consideration. If it does impact reputation in any significant or material way, which is established here by our record evidence and the court below, that the determination that the person is high risk and placement on the registry and the labeling of danger does very clearly affect reputation beyond the conviction. And once you've identified that, strict scrutiny is a necessary application, because that is where the fundamental right is being impaired by the legislative determination.
So all that would need to be established then is that there is a negative impact on reputation as a result of the legislative scheme, and then you apply strict scrutiny. That would be your primary analysis.
Yes, Your Honor, and I think that's accurate.
Mr. Marcus, I think we understand your argument. Do the justices have any further questions? Thank you both. Very well argued.
Good argument, really. Both sides. Thank you.
Mr. Minner, we're going to take a 10-minute break. you call the next case? Thank you.
The Department of Corrections versus Ralph E. Lynn State Civil Service Commission. Representing the Governor's Office of Administration, Mr. Anthony Holbert. Representing the State Civil Service Commission, Ms. Elizabeth Lawson.
We granted allowance of appeal in this matter to determine whether under the Veterans Preference Act, the Civil Service Commission's instruction that Ralph Lynn be afforded veterans preference with respect to a promotional opportunity was erroneous. We also asked the parties to address whether the movement of an employee from a non-civil service position to a civil service position constitutes a promotion for purposes of the Veterans Preference Act. Please proceed.
Thank you, Your Honor. And may it please the Court, my name is Anthony Holbert, and I represent the Office of Administration in this matter. As Your Honors are aware, this case involves the intersection between the Veterans Preference Act and the Commonwealth Civil Service Reform Act. Under the Veterans Preference Act, qualified veterans are entitled to an employment preference in appointment to civil service positions.
Mr. Holbert, would you pull the microphone up? I believe you're a little taller than our last advocate.
Sorry about that. Can you hear me now?
Thank you, yes.
I feel like I'm in the Verizon commercial. So, under the Veterans Preference Act, qualified veterans are entitled to preference in appointments to civil service positions. However, this Court has been clear that the preference cannot be afforded to a veteran seeking a promotional opportunity, as doing so would be unconstitutional. Notwithstanding this Court's precedent that veterans preference cannot be afforded for promotional opportunities, the Commonwealth Court affirmed the Commission's adjudication, which directed the Office of Administration afford Mr. Lynn veterans preference in his promotion to the Corrections Welding Trades Instructor position, or CWTI position. The Commonwealth Court's holding in this matter is in clear contradiction to this Court's unwavering precedent, as it is undisputed that Mr. Lynn's selection for the CWTI position constitutes a promotion under the Civil Service Reform Act. Indeed, even under the Commission's interpretation of the term promotion with respect to veterans preference, Mr. Lynn's selection for the CWTI position clearly constitutes a promotion, and thus, application of the preference is unconstitutional.
Explain, just so I can understand it. When we have the civil service jobs and the non-civil service jobs, the employees are still working within the same system. What does that system mean?
Certainly.
What is system in that context?
Certainly. So the Civil Service Reform Act essentially creates two separate tracks of employment for employees within the Commonwealth, the civil service tract and the non-civil service tract. And under the Civil Service Reform Act, those tracks are treated completely separate. So one individual could be deemed to be in a civil service position, and the Civil Service Reform Act would require, if they're entering into the classified service, that they take an examination, that they pass the examination and be within the selection rule, either the Rule of 3 or an alternate rule, in order to be selected. Alternatively, the second track, non-civil service, while it operates within the general confines of Commonwealth employment, it is treated separately with respect to the selection rules. A non-civil service position is not required to be posted for any period of time or posted at all, and the selection method is not the same as the civil service, as it would not require an examination. It can be a direct hire.
So is the system the Commonwealth, or is the system the department? What is the system?
The system operates Commonwealth-wide. So the classified service and the non-classified service, the classification system, I should say, we have a unified classification system where jobs within the Commonwealth, they apply.
So it's the Commonwealth?
Yes, it's Commonwealth-wide. Sorry.
Yeah.
It is Commonwealth-wide.
Counsel, when Mr. Novotnik got a job, the non-civil service job that he had, when he applied for that, did he get a veteran's preference?
I believe so, yes, ma'am.
Okay.
And moving to the civil service position, because he is moving from a non-civil service position to civil service, he did not meet the statutory definition of promotion contained within the Civil Service Act. And that is why the Office of Administration afforded him the preference in his application to the CWTI position.
So the issue with this case is it's not really whether Lynn should have gotten points, because I think almost everybody agrees Lynn shouldn't have gotten points. The question is really whether Novotnik should have gotten points under our decision in Hoffman. How does the rationale that the court employed in Hoffman not apply with equal force to Mr. Novotny?
Yes, Your Honor. So prior to this instant appeal, this court has not had the opportunity to address the unique situation that's created by the Civil Service Reform Act in having two separate tracks of Commonwealth employment. And so the Office of Administration was constrained to find a way to apply the general rule from Hoffman and Chester, O'Neill, and Schmid that in the promotional context it is unconstitutional to apply veterans preference, but applying that so that it is applicable to all situations within Commonwealth employment, civil service, and non.
Hoffman was a discrimination case. It was a non-factor, non-merit factor discrimination case.
Yes, Your Honor.
Right. And in Hoffman, we said the reason why veterans benefits or veterans preference is a non-merit discriminatory factor for an existing employee is because you have experience with that existing employee. They're already in the system. There's no merit factor to now giving that person who has no experience in the system some bonus for being a veteran. That was the rationale and the reasoning of the court in Hoffman, correct?
Yes, Your Honor.
So what is the rationale in reasoning for giving Mr. Novotny preference points for his veteran status when, applying Hoffman, he was already an employee, they already had experience with him? Why wouldn't that make it a discriminatory non-merit factor?
Yes, Your Honor. The rule advanced in Hoffman and clarified in the Chester County case focuses on the fact that you have two individuals from the same appointing authority applying for the same job, so they are moving within the same structure. However, that does not address all circumstances that could arise under the Civil Service Reform Act or within Commonwealth employment generally, because you can have, given our unified classification system that applies across the Commonwealth, you could have two individuals from two different appointing authorities applying for a job in a third appointing authority. And so the logic of Hoffman, while it is certainly valid within a vacuum, it does not address all circumstances that could arise.
But we don't have that. That factual scenario we don't have here. We don't have somebody going from the Department of Transportation to the Department of Public Welfare. We have one agency, hired them both, had track record with both agencies, both seeking a higher pay, in layperson's terms, promotional situation. Why doesn't the rationale in Hoffman apply?
The Office of Administration tried to create a rule that could be applied across the board in all circumstances.
Well, I'm not asking you why you created a rule. I'm asking you why didn't Hoffman apply?
We are constrained by the promotional definition. The promotional definition of the definition of promotion within the classified service is very rigid. It is expressly stated to moving from one civil service position to another civil service position within a higher classification.
Is that how we define promotion in Hoffman?
No, Your Honor, but Hoffman did not address a situation where you have two individuals applying from two separate tracks of employment.
Which then gets to the second question, and then I'll take a breather. If we were to allow Mr. Novotny to get points in this case, how does that not create another constitutional problem by giving points to someone in non-civil service versus civil service for veterans preference? How does that not become another discriminatory non-merit factor?
I think the Commonwealth Court addressed that in Cutler, where they held that for all civil service appointments, veterans preference must be afforded. And so here, with Mr. Novotny moving from a non-civil service position to a civil service position, that is an appointment. And so within the structure of the Civil Service Reform Act, as well as the Commonwealth Court's decision in Cutler, it begs that the application of veterans preference to Mr. Novotny was correct as his.
I understand the statutory construction argument. I completely get the statutory construction argument and the application of promotion. The problem is that I see is if you follow the statute in this case strictly and you apply the promotional definition in the Civil Service Act, aren't you creating another discrimination claim? That being that you are giving preference to a non-civil service person over a civil service person within the same agency and the same experience, which is essentially a non-merit discriminatory factor.
We would submit that following the law as currently written would not be a non-merit factor as it is.
Well, in Hoffman, the law would have required a preference for a promotion.
Was that a question?
No.
Okay. I believe Justice Mundy had a question.
Kind of along the same lines as Justice Brobson, as I was just concerned that even though we have a civil service employee and a non-civil service employee, they were both on what's been described as a CO 35 pay scale group. And they both were seeking a position as a promotion on a CO 37 pay scale group. So I don't understand why there's a distinction between the two employees myself.
The distinction, unfortunately, comes down to strict construction of the Civil Service Reform Act. The Office of Administration is constrained to follow the act as written.
Well, Counsel, is that true? I mean, maybe you could explain this to me. My understanding is you're much better off having a civil service job than a non-civil service job. Is that correct? I mean, in terms of how you can be dismissed and accrual of benefits and things of that nature.
You are afforded more protections as a civil
It's a whole different job. It's a whole different job. You're applying to become a part of a classification that provides you additional protections than a non-civil service job. So it's more than a promotion. Correct?
It's entering into a completely different track of Commonwealth employment. As you indicated, with civil service employment comes different protections than it would with non-civil service. And again, the Civil Service Reform Act creates those two separate tracks of Commonwealth employment, and for all purposes, it treats those two tracks as completely separate.
But they are. They are. The benefits and protections that are afforded to a member of one classification versus the other are significant. So, I mean, Novotny was essentially applying for a civil service job. He wasn't asking for a promotion. He was applying for a civil service position. And, I mean, I'm trying to make a distinction that's made in the statute and looking for a reason for it being there, and I think that's the reason.
Absolutely, Your Honor.
I mean, it's not, we have to blindly follow it. I mean, there's a rationale for it. It's harder to get rid of somebody who has a civil service position.
Absolutely, Your Honor. When you enter into the classified service, you are entering into a completely different system with respect to the protections, and you are afforded a much higher degree of protection.
A different structure, but the same system.
Yes, Your Honor.
And do we really have Mr. Novotny's claim before us? I mean, as I understand, the only issue before this court is whether Mr. Lynn was treated appropriately in this case.
That is the heart of the matter, is whether or not Mr. Lynn should or should not have been afforded the preference in his promotion to the CWOTI position. I believe, however, as this court has requested the parties address the issue of moving from non-civil service to civil service, the issue of Mr. Novotny's movement is intertwined with the main issue. And going back to the main issue, at the end of the day, the crux of this case, or the heart of this case, is a question of whether or not the Commission has authority to order a remedy that requires the Office of Administration or any other appointing authority to commit an illegal act or an unconstitutional act. And the answer to that question from this court should be and must be a decisive and definitive no. Ultimately here, the remedy that was offered to Mr. Lynn was for him to have the preference applied to him in his promotion. If the Commission and the Commonwealth Court ultimately decided, and if this court decides that the treatment of Mr. Lynn and Mr. Novotny was disparaging and was ultimately a non-merit factor, the remedy is not to violate the Constitution. It is to take the points away from Mr. Novotny. And unfortunately, the Commission does not address that issue in its brief, but at least appears to concede that issue in a footnote. And so ultimately, at the end of the day, if I could sum up this case in one sentence, it is, or in one word, it's remedy. What is the appropriate remedy in a civil service matter? And the Office of Administration would submit that it is not to violate the Pennsylvania Constitution.
Okay. Any other questions? Okay, thank you.
Thank you, Your Honors.
Good morning. May it please the court, I'm Elizabeth Lawson here on behalf of the commission, and I'm also here with my co-counsel, Nicholas Seidelnik. I want to start off by agreeing, something that doesn't happen that often, I think, in court. And we do agree that the remedy would have been to remove those preference points from Mr. Novotny. But what I think the court, both the Commonwealth Court and the commission, focused on was the disparate treatment. That these two individuals were treated differently. And veterans' preference applies to both civil service and non-civil service positions. So, when you're looking at two eligible candidates, what you need to ask first is, are they eligible? Which is a determination that do they meet the minimum education and training? And is this a promotion? Should veterans' preference apply? And I would disagree with counsel on the fact that there wasn't a definition for Mr. Novotny. In fact, there is. It's in the Management Directive 505.7. It is the personnel rules applied to all Commonwealth employees, and I would ask this court to take judicial notice of that. It can be found on the Office of Administration's website, oa.pa.gov, under Policies, Management Directive 505.7. And that definition is nearly identical to the civil service definition. And that is that it is a movement of an employee in a job classification to another job classification assigned to a pay scale group with a higher minimum hourly rate. So the personnel rules definition says minimum hourly rate. The civil service definition looks at the highest maximum salary. But in essence, we're talking about the same thing. You're moving from a pay scale 35 to a pay scale 37. If you apply that definition, whichever one applies, you end up with the result that neither Mr. Novotny nor Mr. Lynn was entitled to veterans' preference. And I really think that's what the Commonwealth Court was trying to say, was that they were treated differently and shouldn't have been.
Well, counsel, the only problem you have is the definition of employee in the Civil Service Act.
But that definition doesn't apply to Mr. Novotny, who's not in the service yet.
I know, but the definition of promotion, if we go by the definition of promotion in the Civil Service Act and don't view our non-merit factor discrimination decision in Hoffman as broader, then promotion is defined about the movement of an employee. And then the definition of employee is limited to employees within the classified service. So if you stick purely on a statutory construction basis to the Civil Service Act, you have a problem because the definition of promotion only talks about promotion of people within the classified service. It doesn't talk about the promotion of somebody outside the classified service into the classified service.
Right, but veterans' preference applies to both. It doesn't just apply to classified service employees. So let's say we have an employee, there's a position at Department of Corrections, which is food service instructor, another kind of instructor position, also a 37, but non-civil service. You would still be doing that promotion analysis from either maintenance foreman or corrections officer to food service instructor because it's still a promotion. I think Hoffman and Chester were intent to provide a broad prohibition, and we shouldn't be focusing on the narrow definition in the Civil Service Act. Is it a promotion? That is the general question that needs to be asked, and there is a definition for both of those.
But we can't ignore, I'm sorry to interrupt you, counsel, we can't ignore the fact that we are talking specifically about the Civil Service Commission. We're talking about one person going into it and one person who's already in it, right?
Right.
So to me, that seems like we are talking about something distinctly, a narrow definition, if you will, the one distinctly pertaining to the Civil Service Commission.
But I think if we focus on that, we then create a loophole for veterans' preference, and I don't think that's what Hoffman wanted. I think the decision...
What kind of loophole? Where's
because if you're...
I didn't mean the commission, I meant within civil service.
Right.
I misspoke.
That's okay. I took it that way. Because if you happen to be a non-civil service person moving into the classified service, you're going to get a benefit that a person like Mr. Lynn, who's already there, but also, in a different kind of position, doesn't get that benefit. That is that non-merit factor discrimination that the commission seeks to prevent from happening.
But Mr. Lynn has had the benefit of being a civil service employee. Mr. Novotny is asking for the veteran's preference to apply to his application to become part of the civil service classification.
But that's not a distinction that the Veterans Preference Act makes. There is nothing that says you get the benefit just because you're entering civil service. It's a benefit that applies across the board to all Commonwealth positions.
Did he get the benefit when he was first retained at Frackville?
That is not in the record,
Well, the
so I
answer to
can't
my
answer that.
question was yes. I asked that question. He said yes, he did get the preference when he became a non-civil service employee. But I don't know if that's neither here nor there. I mean, I'm trying to reconcile a statutory definition with facts that seem to comport with this situation. This individual, Novotny, was applying for a civil service commission employment spot.
And the commission sees it as promotion applies across there is no distinction just because you're entering the classified service. And that is acknowledged by the fact that you can promote from a non-civil service into civil service.
I'm glad you raised that point because I spent a lot of time reading these, your regs that attempt to apply the statutory definition. I mean, frankly, I don't know how you do that based upon the language of the statute.
I do have to say those are the Office of Administration's regs.
Yeah, I mean, I just don't understand. I don't understand the predicate for those regs when I look at the definition in the statute.
I can give you a little bit of history about this. This is not in the record. This is historical to the way the commission had operated even prior to my time there. The Commonwealth had wanted a way for individuals who were in non-civil service positions to be able to move into civil service positions without having to go back and start at the bottom in a classification, so that there was more freedom. We have consistently, and this is consistent with Governor Shapiro as well, is trying to make Commonwealth employment something that's very accessible to people. So this reg mirrors a reg that was in the old regulations. And that was that whole purpose, was to try and make it easier for people to get into the classified service.
I understand that, and I mean, I think it's a wonderful intention, except the definition of promotion in those regs and the definition of promotion in the statutes are polar opposites. I mean, you know, so the commission had a view of what it intended to do. The legislature didn't actually articulate that within the statute, so I'm just struggling with the predicate for it, but I mean, I know it's an ancillary argument here, but it does, you know, raise an eyebrow when you look at it. But why isn't it important that Novotny was, for the first time, applying for a civil service position, in which case he would be entitled to the veteran's preference because it wasn't a promotion. It was an application for a new position with the civil service.
I think because promotion is separate and distinguishable from entering the classified service. That is an idea that exists across the board. So I think you need to apply veterans' preference accordingly, as the Veterans Preference Act requires us to do, which is when there is a preference, it doesn't apply. So that's the only answer I can give, is that, you know.
Counsel,
yes.
Is it the commission's position that any time an employee moves for any type of promotion, that they are provided with the veteran's preference?
No. As I said, our position was we were looking at the disparate treatment of these two individuals. We agree if it's a promotion, there should be no preference.
And then under the question, the question I have is under the veteran's preference, I believe the language is hiring or retention. Correct?
Well, let me...
And if it says retention, share with me where promotions in the Veterans Preference Act.
They specifically removed that from 7104. That was in, promotion was in that heading.
But it was removed.
It was removed. In
The 78 Act, I believe, is the most current.
Well, there were amendments in 2020, and I believe also 2022, those don't apply in this case because this case actually happened in 2019. So, but at the time, in 2020, the legislation was amended to remove appointment in accordance with Hoffman. That's this note that's specifically made, is to recognize that it does not apply in promotions ever.
It does apply in hiring. And so if one is being hired into a civil service position, then you get the veteran's preference.
I think you could also argue that the person has already been hired.
Well, I'm trying to work with the statute that we have here. I mean, and I don't see a mismatch in this circumstance because of the fact that Mr. Novotny was being hired into a civil service position. So the veteran's preference applies. We're all in agreement that it didn't apply to Lynn. We can reconcile the statute with the factual circumstances of this case. Unless you disagree with the proposition that it is a substantive benefit to be a civil service employee versus not being a civil service employee.
Oh, no, I agree. There are many benefits to being a civil service employee.
That's why you need to be hired into it.
Right.
Isn't the focus, though, is the question is, if we, and I completely agree with my colleagues are saying, the statute is not your friend here. But the statute wasn't the friend in Hoffman either. That's why we said the language that gave points to promotional examinations was a discriminatory non-merit factor.
Right.
Your point would be, sort of to the second issue the court asked you to give, is if this is the position, and if this is what the statute says, then giving preference point to an existing employee who is non-civil service is a discriminatory non-merit factor because they're already in the system. You already have experience with them as an employee. There's no additional merit that the veteran's experience gives that person over the existing employee. That's your argument.
That's excellent. I don't need to repeat it. That is my argument, and also that I think we need to be treating people fairly across the board. Ultimately, there is a fundamental sense of fairness that I see in this, that there shouldn't be this loophole that if you just happen to be in just the right place at the right time, you get those veterans' preference.
I think I would take issue with you. I think I'd be the third justice to take issue. It's not about loophole. It's a question of applying the statute the way it is written. Does it give rise in certain facts to a discrimination claim? And that's really the question, is whether if points are given to Mr. Novotny under these facts and not to Mr. Lynn, which Mr. Lynn obviously can't get them, is that discrimination under the Civil Service Act? And that's really the question.
Ms. Lawson, you both, were you going to ask her to respond to that?
No.
Okay. I don't want to cut you off if you're waiting for an answer. I think we understand it. They're both good arguments. I mean, you both have an arguable position here that we'll consider. So do you want to wrap up, Ms. Lawson? Anything else?
Actually, I think Justice Brobson I dropped the mic kind of thing. To the commission, there was merit factor discrimination here.
We understand. Thank you.
Thank you.
A.M.D. versus A.L.R. A.D.R. Representing appellants, Ms. Catherine Jonas Hunter. Representing appellees, Mr. Paul Warner.
Still morning. Good morning. In this matter, we are asked to consider whether the trial court's order that grandparents have standing to seek partial physical custody of their grandchildren is appealable under the collateral order doctrine. Specifically, we must determine whether parents who are challenging grandparents' standing have satisfied the third prong of that doctrine, which requires them to demonstrate that their rights will be irreparably lost if review of the trial court's order is postponed until a final custody award is entered.
Thank you. May it please the court, Catherine Jonas Hunter on behalf of the appellants, A.L.R. and T.A.D.R., which I'm going to be referring to as mother or father or collectively as parents for the ease of the court following my arguments. Similarly, with respect to the appellees, I'm going to be referring to them as maternal grandparents. As the Chief Justice so indicated, the biggest issue here is the third prong, whether or not a claim will be irreparably lost. The claim in this matter that would be irreparably lost is the parent's constitutional right to raise their children as they deem appropriate by the parents, free from the intrusion of a third party. This court in Hiller, citing Troxel, determined that the right to make decisions concerning the care, custody, and control over one's children is one of the oldest, and may I also add, most sacred fundamental rights protected by the Due Process Clause of the 14th Amendment.
Counsel, you're presuming that, I take it, you're presuming that the trial court is going to award some interim custody to grandparents, which is not in the case, right?
Right.
Well, so, Justice Wecht, I would respectfully disagree that there's a presumption. A standard practice in York County, as maybe in some other of the 59 other counties, is at conciliation a couple weeks after standing has been determined and the complaint filed and properly served. A conciliator does award interim rights. It happens on a routine and regular basis and is actually rarer in circumstance when that does not happen. So pending a custody trial, which could take place 6 months later, grandparents would have some sort of custody rights, and therefore my client's rights would be irreparably lost because grandparents would have these rights pending the trial.
Counsel, share with us. The only issue before this court is whether there is standing. This is not a merits analysis. And we're talking about specifically 5325, the grandparent statute. Share with me where in your argument that the grandparents don't meet one of the elements of 5325, that being, 3, that they lived with the family previous year? Are you contesting the fact that the maternal grandparents lived in the home?
No, Your Honor. I am not contesting that they do not meet the statutory requirements for standing.
But that's why we're here. That's the only reason we're here.
The problem is this is factually specific in this matter. The parents, who are the defendants, are an intact family, and their constitutional right to raise their children as they see fit, free from the intrusions of the grandparents, is at issue with the statute allowing them to have standing.
We didn't grant on the constitutionality of the grandparent statute, which may be an issue down the line in a merits appeal. Right now, you're litigating this standing appeal against the backdrop of a statute that does, in the General Assembly's wisdom, wisdom or lack of it, that's an issue to debate, right? But they've chosen to give grandparents these rights, and so you need to establish that the grandparents being in this mix in the meantime is somehow irreparable harm. And you have to do that against the backdrop that in this case, they've been in the mix in these children's lives for years.
And the policy that the General Assembly believes that grandparents are essential to the health and welfare of the child. Not that you don't have a founded argument, but the issue before us, is it a collateral order? Or did they meet the statute such that it has to go to a hearing?
Well, and Justices, I would respectfully argue that it needs to be fact-specific. And in this case, there is a problem. In any other case where there isn't an intact family, certainly the statute would be appropriate. But there is an intact family with parents who have decided that they do not wish for the grandparents to be involved. And there were problems with grandparents' involvement prior to the parents leaving the residence. The trial court did find that while the grandparents had standing, it was solely on the basis that the parents lived with them for more than 12 months with the children. They didn't have in loco parentis. The trial court didn't determine that there was necessarily a bond. In fact, it was likened to parents who were sharing a residence with non-familial entities, such as a roommate.
Yeah, but the statute doesn't liken grandparents to non-familial roommates. The statute specifically elevates grandparents in the General Assembly's judgment So again, pending the litigation and pending whatever the trial court does down there in the meantime, how do you come before us and establish irreparable harm?
Again, Your Honor, I'll revert back to the irreparable harm is my client's constitutional rights.
Counsel, can I help you out here? And maybe I read more into your brief than was there, or your argument than was there, but I thought the right that was being lost here was your client's right to be free of the burden of custody litigation that was recognized in Troxel. Is that your argument or not?
That is yet another argument.
It's not another argument. It can be your only argument because you have your clients have not lost custody. I mean, you have to identify a right that's something other than I'm an intact family and nobody can interfere with it. You have to rely on a right, if there is one, to be free of custody litigation. Is there such a right?
And it was my argument also in my brief, as I'm sure the court has noted.
But that's the right that will be lost if you don't get an immediate appeal because you will be involved in the custody litigation until it's done.
Correct. And the courts have repeatedly observed that custody litigation is expensive. An appeal after the litigation is a burden on both parties and ultimately stressful to the children at issue, which although these children are at tender years and likely would not testify in this matter, still, if it was to be appealed and then remanded again for another hearing, the children will be burdened by interviews by the court. In addition, the financial stress on everyone involved, including the grandparents, will be a burden that cannot be corrected.
Would you agree, counsel, that in order for you to prevail here, we would necessarily need to determine that the grandparent custody statute is unconstitutional?
I don't necessarily agree because, again, fact-specific. In this matter, it is litigation that is two parents that are an intact family. I think if you look back to each particular instance, and I think in this case, one of the difficulties is that the trial court determined that solely on the basis of the parents living with the grandparents, that causes the grandparents to have standing. I think that is problematic for the court. I'm not suggesting that it needs to be unconstitutional, and I understand that that wouldn't be right for this court to determine at this time anyhow.
The counsel, let's look. 5324 is permitting custody where the grandparents in the appropriate situation can be provided primary or sole legal custody or physical custody. 5325, known as the grandparent statute, is specifically created for the purposes of partial physical custody or supervised physical custody, aka grandparents get to see the grandchild. Share with me where in that statute your argument has merit. It's going to the merit. This is not a merit analysis. This is looking at the statute and the black letter of the law, the plain language, and do they meet the statute? The answer is yes. The question before us is that definition of yes subject to collateral review, or must it be played out in the courtroom? So why don't you share with us your argument why it meets a collateral review argument as opposed to the meritorious constitutional challenge?
So, and I will go back to the argument about the stress that litigation puts on all parties in addition to the children. That cannot be undone, and therefore our position is...
The reality, let's play your game. What that means is the purpose of the statute is so that the grandparents have to incur legal costs so that they can see the grandchildren they love because the parents are blocking them from sharing that love. So how is that incumbent upon your clients having a fiscal problem when it's their conduct which has caused this litigation?
Yes, but ultimately, if the case is litigated and then an appeal filed and it is determined at the conclusion of it that grandparents did not have the appropriate standing or ability to have any custody rights, then we are back at the same issue that the grandparents wouldn't have had to spend that money anyways, but the parents would not have had to.
But the argument, as indicated by Justice Sweck, was your appropriate issue before this court is that 5325 is an unconstitutional statute because it infringes upon the fundamental right to raise children. That's not before us, just the language of the statute.
Counsel, let me follow up on that question. Let's see if we could just take this to its logical conclusion. Let's say that we say you have standing to appeal, okay, and we send it back to the Superior Court. Okay, all we're asked to decide is whether the three prongs of the collateral order are fulfilled here. If we all end up agreeing with you that the question presented is such that if a review is postponed, it'll be lost, and it'll be lost because you'll have engaged in all of the litigation involving the custody. And so we say, okay, you have standing to challenge the grandparents' standing that the trial court found. What are you going to argue in the Superior Court now that we send you back there? What's your argument to the Superior Court challenging the trial court's determination that the grandparents had standing? What's your argument?
It is the same argument that they do not have standing based solely upon this statute, and if they do have standing, then the statute should be reconsidered as possibly unconstitutional.
Have you preserved that challenge? Because that's how I view this case. I mean, your only question to us is, should the Superior Court be able to review the standing conclusion of the trial court? Correct?
Yes, Your Honor.
Okay. Now, have you preserved your challenge to the constitutionality of this statute so that the Superior Court, not us, but the Superior Court can decide it?
Yes, Your Honor. When preliminary objections were filed on the basis of standing, that issue was raised in the preliminary objections filing. Subsequently to that, the trial court held a hearing on the preliminary objections and made these factual determinations.
So you're not asking us to decide the constitutional question or the validity of your other preliminary objections. You're asking us to allow the Superior Court to hear the appeal.
Correct.
As a collateral order.
Could I follow up on that then, counsel? If you were to, and I think we all recognize you want to get to the constitutional issue, but it's just not here yet. For you to prevail, wouldn't we have to, if we're putting aside the constitutional question, and we are, right, isn't it the only other way you could prevail would be for us to hold that burdening a right is the same as that right being irreparably lost or irreparably harmed? And if that's the case, then wouldn't this holding have really, really far-reaching implications beyond this case of a problematic nature, piecemeal litigation-wise?
I would respectfully disagree that this would be burdening a right as opposed to an irreparable harm. Once you have spent money on expensive custody litigation, it cannot be retrieved. In addition to that, the burden financially, not only financially, but also emotionally on all the parties involved and the children also cannot be repaired. And so thus I would say that it's not necessarily a burden, but it is a irreparable harm.
We followed your argument to the logical extreme. How would any case ever get before court? Because every case, when you retain private counsel other than a public defender, involves emotion and money.
Even more so when it is a family law matter, though, Your Honor.
You can't say that to a person who lost a family member that died in a catastrophic accident. They think that is more upsetting than mom not letting grandmom see the baby.
Understood. So I think everyone's case is very important to them, but when the court is dealing with the best interest of the child, I think that we have even a higher duty, because this is really not about the appellants or the appellees, but it is about what's in the best interest of these children. And in order to achieve that, we have to deal with this issue of standing first.
Well, we've already got the fast track in Superior Court, and Superior Court has no shortage of custody appeals. I think we can all agree on that. I'm not sure if you've contemplated the enormous burden on the Superior Court that you would create if you were to prevail. Do you want to comment on that?
So I think it is an important issue to deal with, given that I would be requesting from the Superior Court to deal with the constitutionality of a standing statute. And so it may be not the run-of-the-mill typical litigant who is unhappy with the result at the trial court level and files an appeal, which they have a right to do, but rather in this matter, we would be dealing with an issue that may have far-reaching implications later on.
All right, anything else?
No, thank you.
All right, thank you. Let's hear from Mr. Royer.
Chief Justice Todd, fellow members of the court, I was prepared to work through each prong of the collateral order doctrine, but in hearing the issue as phrased by the Chief Justice, I think in the interest of brevity, I'll focus on the third prong. That being said, frankly, walking in here today, I was prepared to cede this argument that standing is severable from the underlying issue. But what I'm hearing today from the appellant is that this is so fact-specific, that it's not a separate legal doctrine, that this standing is somehow related to the underlying facts of the case, which in essence is self-defeating of the first prong.
Counsel, haven't you agreed that the first and second prongs are met?
I am not agreeing, Judge, not after what I heard today.
I thought I read your brief to suggest
Well,
that.
look, before today, I was certainly happy to do so with respects to the first prong.
Right? I thought you agreed that there was some rights to be free of the burden of the litigation. No?
I don't believe so, and I'm certainly happy to address that next.
Yeah.
With regards to, let me jump to the third prong, if I may, Justice, and perhaps that'll answer your question. First of all, I think it's important to note that the trial court in the case law is clear that they have an unparalleled importance of protecting the best interests of the child, which I feel that is encapsulated in 5325. With respect to what we heard of this constitutional argument, I would respectfully submit that in order to assert this constitutional argument, that the right to be free from litigation, the right to parent as they see fit, in order to assert that constitutional challenge, they have to do so in such a fashion as to challenge the constitutionality of 5325. In the notice of appeal and concise statements there too, she raises the issue of the right to be free from litigation, but there's no direct challenge to 5325. Additionally, I would respectfully submit that the OAG would have to be put on notice of that challenge if it were to be properly put before the court. With respect to the third prong, Justice, if I may, if that answered your question. This idea that that this claim is going to be lost it's folly. The case law doesn't support it. Had this case gone to the natural conclusion, conciliation, a marriage trial if need be, she is correct in that at least the argument on standing would have been preserved via POs. For my colleague to argue that her client is to be free from protracted litigation strikes me as disingenuous. The fact that the appeal was noted, this case would have been to conciliation already. It would have gone to a merits hearing, and maybe the appeal would have been filed, but we don't know that. The trial court was studious in its opinion on standing when it said, to be clear to the parties, this is only a ruling on standing. It said specifically to the parties that there has been no determination as to partial custody rights. And I think it's important to notice that, this idea that that order did not grant any temporary physical custody rights to my clients. There's been no infringement upon their right to parent, other than having...
Also, if there is a right to be free of custody litigation in a circumstance such as this, that right will be lost.
But respectfully...
They're two different, there's a right and then the subset of the right. I'm just referring to Troxel. I mean, maybe you have an argument that there is no right to be free of custody litigation, and that's could be a perfectly legitimate point. But, on the black letter language of Troxel, it would indicate that there is a right to be free of the burden of custody litigation. That's the right, and it's the right she's claiming here. It's the right that she's claiming to establish a collateral order. It has nothing to do with the ultimate right to have control over how the children are raised.
Respectfully, Your Honor, my sense is that this constitutional argument, the right to be free from custody litigation, is being asserted by the appellant to gloss over the third prong of the rule. In other words, they don't argue why this claim will be equitably lost.
Because she'd have to be involved in the entirety of the custody litigation before the family court judge. That's the litigation that's being referenced.
Agreed, but by nature of the appeal that was filed after the standing order came down, they themselves have protracted that litigation.
Not if she wins. I mean, she took an appeal on the parents took an appeal with the view in mind that they would ultimately be successful before the Superior Court if the Superior Court would hear their case. Then it would be over. The litigation would be over.
Understood, Your Honor, but yet here we are.
Counsel, there was one point when Appellant's Petitioner's Counsel was arguing where there was a lot of questions about whether the Superior Court, whether the issues in front of the Superior Court included a constitutional challenge to the grandparent standing statute. Do you believe that that was raised and preserved in the Superior Court?
Not effectively, Your Honor. My sense is that the only issue she raised was whether there's this inherent right to be free from litigation.
And that
no direct challenge.
That related more to the standing concept, which the statute gives standing.
Correct. There's no direct challenge to 5325. It's my humble opinion that to raise that issue in and of itself would have to contain a challenge to 5325.
As well as notice to the Attorney General.
Yeah, exactly. And I don't think this idea that the right to be free from litigation can exist independently without a challenge to 5325, which encapsulates the best interest, this unparalleled purpose of the trial courts.
Any other questions? Thank you both.
Thank you.
Matthew Rush and Kathleen Brogan Rush versus Erie Insurance Exchange, representing Erie Insurance, Mr. Glenn Chickenoff, representing the Rushes, Mr. James Haggerty, and Mr. Scott Cooper.
In this appeal by allowance, where a police officer was injured in an accident while driving his police vehicle, we must determine whether the regular use exclusion in his personal auto insurance policy, which precludes recovery of underinsured motorist benefits for an insured who is injured while operating a motor vehicle that is not expressly listed on the policy and that the insured does not own but regularly uses, violates the Motor Vehicle Financial Responsibility Law. Please proceed.
Thank you, Your Honor. May it please the Court. Glenn Chickenoff for Appellant Erie Insurance Exchange. Your Honor, the intent behind the regular use exclusion and the reason why it's included in nearly all auto insurance policies in Pennsylvania is to shield insurance companies from having to provide coverage for risk that is unknown, uncompensated, and most importantly, of the type that an insurance company may simply not be willing to insure. Boiled down to its simplest form, it prevents a claimant from purchasing a single vehicle policy on a Honda Civic, stashing the Honda Civic in a garage, never to use it again, while operating regularly each and every day hundreds and hundreds of vehicles within his employees' fleet, whether it's police vehicles, trucks, NASCAR cars, etc. That's the intent of the exclusion, in order to prevent the insurance company from having to provide that coverage. Now, the MVFRL was amended in 1990, in July of 1990, and those are known as the Act 6 amendments. Since the Act 6 amendments were enacted, this exclusion has been challenged no less than 24 times. It has been upheld each and every time by the appellate courts. It has been challenged twice before this court, first in 2002 in the Burstein versus Prudential decision, and then again in 2011 in the Williams versus Geico decision. Both times, this court held that the exclusion does not violate the MVFRL. Despite precedent directly on point, the three-judge panel of the Superior Court inexplicably labeled this issue as one of first impression. The three-judge panel did not cite to a single Superior Court case that was published and that it was bound by. It didn't cite to the Burstein decision from this court at all. And in citing to the Williams decision, it spent all of 2 sentences. The first sentence, which conceded that in Williams, this court found that the exclusion does not violate Section 1731 of the MVFRL. The second sentence explained that that finding was dicta and therefore does not need to be followed. In doing so, the Superior Court erred in refusing to follow precedent, refusing to follow the statutory provisions of Section 1731, as well as their intent. For that reason, the panel should be reversed. Your Honors, this court has heard challenges to this exclusion expressly as a violation of Section 1731 in the Williams versus Geico decision. Coincidentally, that was also a police officer case where a police officer was occupying one of his fleet vehicles, was injured, and sought coverage from a household personal auto policy that did not insure those vehicles and contained a regular use exclusion. The claimant in that case argued that the regular use exclusion violates the policy of the MVFRL as well as Section 1731. This court spent 5 paragraphs explaining that the exclusion is consistent with Section 1731 specifically. In fact, direct quote from the Williams case is the regular use exclusion does not violate the statutory provisions of the MVFRL. I'm unsure how else to read that. That statement is not ambiguous.
Counsel.
Absolutely.
Your entire premise of your argument is this unknown risk, per se, or stashing your car in the garage while you drive hundreds. Share with me why that wasn't contemplated in 1733.
Well, Your Honor, 1733 doesn't speak to risk or payment of benefits at all. Section 1733 is actually entitled Priority of Recovery. It's limited specifically to codifying and instructing insurers, when there's multiple insurance policies, which one pays first and which one pays second. There is no mandate to actually make payment absent any policy provisions or exclusions. And how we know that in interpreting Section 1733 is that exact argument was raised before this court in Burstein versus Prudential. In a single sentence, the court rejected that argument, stating that Section 1733 does not require payment above known and established exclusions. So Section 1733 and its argument is limited really to priority of payment amongst insurance companies. And you'll notice that even the panel of this Superior Court that we're appealing didn't buy that argument. Appellees spent a total of 1 page analyzing it in their brief because it's a frivolous argument. It's just not what Section 1733 states. But what the panel did buy is an argument against Section 1731. And I submit that that's simply not the requirement within that section.
Counsel, can I ask you about Williams? Did it lose vitality as a result of Gallagher, since Williams relied on Baker, and Baker was overruled by Gallagher?
It did not, Your Honor. The Williams decision cited to Baker by analogy. But if we review the Baker decision, it analyzed a different exclusion under a different set of facts and against a different statutory provision, Section 1738, which isn't even implicated in this case, according to this Superior Court panel itself. And if you review Gallagher and you look at the facts of it, that's how we know that it simply doesn't implicate either Williams or the case in this, or the case before this court.
Counsel, can I have a really basic question for you. Maybe you could help me out with this. Is underinsured motorist insurance portable? And if not, why not?
So, Your Honor, as with any insurance, there is a level of portability that's inherent to auto insurance. However, that level of portability is not absolute. It does not defeat certain policy provisions or exclusions. It does not provide unlimited coverage wherever you travel, whatever you do.
See, that sort of begs the question, doesn't it? I mean, if it's intended to be portable, then you can't have exclusions that make it not portable. And that's sort of the strain that we haven't quite grappled with in our cases since 2016. Former Chief Justice Saylor spent a lot of time in dissenting opinions analyzing this issue of portability. And he leaned in favor of finding portability until a majority of the court found otherwise for different reasons, not on the portability issue. And then after that point in time, he just dissented from various decisions that this court made. But he made his point pretty clear that the analytical point really is, did the legislature intend for underinsured and uninsured motorist coverage to be portable? It covers personal injuries. By definition, it covers individuals, not vehicles. 1731, which is what the Superior Court focused on, is a section of the statute that clearly suggests portability. And so why isn't it portable? Why isn't this insurance portable?
Well, Your Honor, I'd like to break that question up into two, if I may. First, the portability argument itself and Justice Saylor's dissents, as well as Section 1731 thereafter. The portability argument was actually raised expressly in Burstein versus Prudential, expressly challenging the regular use exclusion, and this court rejected it. This court explained in Burstein that the level of portability does not rise to the level of having to defeat known and long-standing exclusions.
Except let me just follow through on that with you. Burstein was really based on a public policy issue that was somewhere up here. I mean, the public policy issue being protection of first responders that was being weighed by this court for whatever reason against the cost containment provisions of the Motor Vehicle Financial Responsibility Law. And I agree with you that there was some discussion of portability, but the overriding direction of that case dealt with this competing overriding policies, and the court came up in favor of cost containment under the Motor Vehicle Financial Responsibility Law. So that's why I'm not sold on this notion that the portability issue was actually decided. Certainly, Chief Justice Saylor didn't think it was when he wrote the dissent in Burstein. I mean, so, and it wasn't that he was dissenting from a clear holding of the majority. It was that, in his view, it was the Insurance Commission that had to make this call on the ambiguity, if there was any, regarding portability or not.
That's correct for the dissent in the Burstein decision, but I'd note Justice Saylor's concurrence in the Williams decision 9 years later. That concurrence was written expressly to underline the fact that in the 9 years in the interim between Burstein and Williams, the legislature simply has not acted. And so Justice Saylor, in his concurrence, explained that due to this inaction by the legislature, he believes that it's up to the insurance companies to decide which risk they're willing to insure and under what circumstances. The portability argument is a self-defeating argument because in order for it to be valid, we would have to take into assumption that any insurance policy has to be written with no provisions, no exclusions, no limitations of any kind. According to the Superior Court, which relied on Section 1731, UIM policies have to be a single sentence. If you are involved in an auto accident for which you are not responsible, you get underinsured motorist coverage.
Unless you've waived it.
Unless you waived it, that's correct. And if you waived it, there would be no endorsement.
Which the statute says, I mean, you can waive it.
That's correct, Your Honor. It's optional. But what the statute says in Section 1731 is actually any time a policy is delivered or issued in Pennsylvania, you have to offer to write coverage in the policy. There's no mandate to pay it. And that's not my interpretation of it, Your Honor. That's what this court decided in Penn National versus Black in 2007. In that case, another policy limitation was challenged as invalid and contrary to Section 1731. And what this court said, and this is block quoted within my brief, I realize the court oftentimes disallows or dislikes block quotes, but I thought it was important enough. The Penn National versus Black court explained that once the policy includes UIM coverage that's equal to or less than the liability coverage on the policy, the insurer satisfies Section 1731 requirements. There is no requirement to pay benefits under any and all circumstances. And it's easy to see why. If the Superior Court was correct, each and every exclusion would fall. Intentional acts, racing, NASCAR drivers would be insured. Full-time truck drivers that operate, and I looked this up prior to coming to this argument, Your Honors, 80 to 110,000 miles per year is what a full-time truck driver drives 18-wheelers around the country. Those vehicles have less visibility, higher cargo, they have less maneuverability, they have higher exposure when they actually get involved in the accidents due to their weight, but also those drivers get incentivized to meet deadlines, to drop off cargo faster, to pick it up faster, and they get financial bonuses to drive through the night to do that. The regular use exclusion is what prevents that truck driver from purchasing a Honda Civic policy in his garage and then operating 1,000 trucks within his employer's fleet. Insurance companies are not required to subsidize that risk. They're simply unwilling to, and nothing in the statute requires them.
Well, it's not just insurance companies, it's then spread across all policyholders.
Well, that's correct, Your Honor. And really, that comes down to...
They're not going to swallow it. They're going to pass it on to the...
That's correct, Your Honor. And the cost containment principles, I realize this court has, in recent years, had some vitriol towards the mention of cost containment. With that said, Your Honor, Chief Justice Todd authored the Safe Auto versus Oriental Guillermo decision, where you explain the cost containment remains at least a factor. In that decision, the plaintiff challenged an exclusion as violative of the MDFRL and explained effectively that the MDFRL requires coverage. In denying that position, Your Honor authored an opinion that has the overarching theme for this entire case. What Your Honor wrote in that majority holding is that absent an MDFRL statutory provision that requires coverage or requires benefits to be provided in a given policy or under a given set of circumstances, the insurance companies are free to write policies that do not cover given risk. This is exactly what happened here. That's the whole theme of this appeal. There is nothing in the MDFRL that requires absolute coverage with no limitations of any kind to ensure each and every risk we can think of. In 2021, Your Honor, Justice Wecht authored a concurrence in the Donovan versus State Farm decision. And in that concurrence, you explained that this court has become the umpiring exclusion court. I submit that this is a chance to rectify that issue. Because if the Superior Court panel's decision is correct, if that reasoning is correct, each and every exclusion will fall. Each and every limitation will fall. This will become the wild, wild west of insurance. We would have to effectively rescind all precedent that has ever upheld any of these exclusions in the past 33 years since the Act 6 amendments have been enacted. It's not what the legislature intended, but that's what the Superior Court believed. They believed that UIM coverage is all or nothing. You either buy it and you get it, or you reject it and then there's no UIM endorsement to begin with, so there's not even an exclusion to discuss. That's every truck driver, every NASCAR driver, every police officer. And I'd like to point out your concurring opinion, Chief Justice Todd, in Williams versus Geico, because I think it could serve as the majority opinion in this case. You spent a lengthy concurring opinion explaining specifically that the legislature must act in order to provide first responders with additional protections. You authored that opinion explaining that the Workers' Compensation Act, that the Heart and Lung Act are available, and that the legislature could act in order to specifically cover these types of risks. But they haven't. And it is not up to private insurance companies to subsidize legislative inaction. In affirming the regular use exclusion, Your Honor in that concurrence explained that this is a legislative, not a judicial issue. And it is not for the private insurance companies to simply provide that type of coverage absent legislative action. In fact, I'd submit, Your Honor, that your example in Williams versus concurrence as to what should be done is a good one. Legislation passed to require that police departments or first responding departments purchase a certain level of coverage as a mandatory provision for their employees is a good one. In fact, Mr. Rush had that coverage here. He had $35,000 in UIM coverage available to him. He believes he needed to get more, and maybe he could have bargained with his police department either individually or as a collective bargaining unit to get that. Maybe he could have discussed with his independent agent whether there were other options in the market. Maybe he could have refused to drive a vehicle regularly. He could have done all of those things, but whether he did or didn't is not relevant to the challenges to this exclusion, because as long as there's no statute that requires this coverage, the insurance company should be free to exclude it, because
Maybe we could send the legislature another copy of that concurrence.
Your Honor, I'm entirely with that. Let's make that concurrence the majority opinion here, uphold the regular use exclusion, and we'll simply... That would be my submission, but I'm obviously not sitting up there before the court. So with that, Your Honors, the precedent on this is clear. Section 1731 does not require mandatory coverage under all circumstances. No court has ever agreed with this. This court has rejected it expressly in multiple decisions cited within our brief, Penn National v. Black, Williams v. Geico, Hall v. Amica, over and over again, because that does not make sense.
Does Gallagher call into question those previous holdings?
It does not, Your Honor, because Gallagher actually is entirely inapplicable to this case. In Gallagher, Mr. Gallagher went to an insurance company to buy policies on his 2 vehicles and a motorcycle. The insurer required him to pay premiums for all 3 of those vehicles, but then split those vehicles into 2 separate policies. So the risk was known. It was compensated because the insurance company received a premium for all 3 vehicles. And it was the type of risk that the insurance company was willing to insure. They actually agreed to write the policies. None of those factors exist in this case. Erie did...
Household exclusion was supposed to apply.
Well, Your Honor, the household exclusion was stricken under those facts, specifically because Section 1738 and its requirements triggered. 3 months ago, this court issued the Mione v. Erie decision, which Your Honor, Justice Wecht authored, specifically explaining that Gallagher has a limited circumstance that specifically restricted the household exclusion under the facts when it violates Section 1738. In this case, Section 1738 is simply inapplicable. Mr. Rush is a guest passenger. This court has already ruled that Section 1738 only applies to named insureds and resident relatives. The fact that he happened to be in a police vehicle is dispositive in this case, and that's the reason that Gallagher is inapplicable, even if we take out those 3 factors to begin with, which are dispositive in their own right. So for those reasons, Your Honor, unless the court has any other questions, the precedent on this is clear, the statutory intent on this is clear. Superior Court got this wrong. I ask this to be reversed, Your Honor.
Thank you, Mr. Schickenough. We'll hear from the Applts.
Good afternoon, Your Honors. Madam Chief Justice, Justices of the Supreme Court, it's always a pleasure and honor to appear before this tribunal. May it please the Court, on behalf of the Applts, James Haggerty, along with Scott Cooper and Mark Altomos. With the Court's indulgence, we will divide up our argument. I will address the historical development and purpose of the exclusion, and Mr. Cooper will then address how the exclusion violates the financial responsibility law. We're talking here about the regular use exclusion, which is referred to as a known and long-standing exclusion. This known and long-standing exclusion did not appear in auto policies in Pennsylvania until the early 2000s. This exclusion was not in auto policies in UM and UIM endorsements in Pennsylvania from the time of the enactment of the financial responsibility law in 1984 until sometime around 2004 when the companies got wind of the decision in Burstein and they started putting it in their policies. It's always been in the policies in liability coverage. It makes sense in liability coverage. It does not make sense and does not comport with the portability aspects of UM and UIM coverage. Let's take an example and let's look at how these premiums are set. Let's take a bus driver, okay? The bus driver gets liability coverage and he gets UIM coverage. The insurance company has no desire to insure and provide liability coverage, and they exclude it for a regularly used vehicle. They do not want to provide coverage over and above what the bus company provides if the bus driver is at fault, so that they are responsible for the 50 people on the bus. When liability coverage is rated and underwritten, carriers look to the age of the person, the driving record of the person, the vehicles, et cetera, et cetera. When they underwrite and UIM coverages, carriers look at two issues: the geographic region and the limits of coverage. Because you're not insuring the negligence of your insured, you are insuring the negligence of others. It's other people. So in the situation of a policy in Pennsylvania, it makes sense to exclude regular use for liability. It doesn't make any sense to exclude regular use for and UIM. This exclusion did not appear until after the Burstein case was decided. The considerations that support enforcing it in the liability case do not exist in supporting it in the uninsured and underinsured motorist situation. Frankly, as Mr. Cooper will elaborate, the exclusion violates the mandate of coverage of the financial responsibility law. The financial responsibility law allows you to elect and UIM coverage, and if you elect it, it first covers the vehicle you're in, but then it follows you. There's no reference to the vehicle. It doesn't matter. This is an exclusion that the carriers talk about, and we've heard about unknown risks for which premiums were not accepted. It's a known risk. How do we know it's known? They fashioned an exclusion to exclude it. Yes, we know it.
He's driving a vehicle owned by a municipality.
You can't. You can't. It's impossible. No carrier will say, I will give you an exemption from that exclusion. And what the carriers are saying is, so what happened is the Burstein case comes along because Prudential had it in their exclusion. Burstein comes along and the court says, yeah, it's a good exclusion. All of a sudden the carriers start running in to put it in their policies. Why? Is this because to protect against an unknown risk? No. It's to not pay claims. Let's look at how premiums are set. Premiums are set upon historical payouts. So if I'm paying out a claim, I'm paying out a risk, that's factored into premiums. So from 1984 to 2004, carriers don't have this exclusion in their policies. They are collecting premiums for that. They are paying those claims. This is a known risk. Burstein comes along, oh, we don't have to pay it. Let's put that exclusion in our policy. So do we reduce our premiums? Come on. No, we don't reduce our premiums. Now we've excluded the risk. We're still collecting premiums for that risk because we have our 5-year history of paying those claims.
Okay. What would be your response to counsel's argument? You buy a beat-up, or you buy a nice car, you get nice insurance, you park the car, and you drive an SUV or something, and now you're in an accident. What's the justification?
You know, it's the same thing I did when I was defending these cases. I would always argue, oh my God, if you invalidate this, it's going to be the end of the world. It's the end of civilization as we know it. It's going to be complete chaos. Frankly stated, that doesn't happen. First of all, how many people in the Commonwealth understand uninsured and underinsured motorist coverages? How many of them understand? How many practitioners understand it?
How many judges?
Except for this group, not many. So it's a nice example that someone's going to say, oh, see, I know because of this, the way they interpret this exclusion, what I'll do is I'll insure this car for $1 million and my 4 other cars for 15, and I get gratis coverage. Find me somebody in the Commonwealth who's that bright and that conniving.
But counsel,
Counsel,
isn't the answer to Justice Doherty's question, so what? You still purchased uninsured motorist coverage.
Yes.
Isn't that the answer?
Yes.
If you keep your car locked in a garage?
Exactly, because you purchase the coverage and the coverage follows you. Why couldn't an insurer, and they're saying, well, this is an unknown risk. It's not an unknown risk. It's a known risk. Okay? Why don't we put an exclusion that says you do not have uninsured or underinsured motorist coverage if you have to cross more than a 4-lane road in walking to work? Why not? How's that any different than driving a tractor trailer? Why not?
And And what's your position with regard to the fact that if we were to agree with your position, we are in essence eradicating any type of exclusion?
No, that again, that's another end of civilization as we know it argument. This court and all courts in the Commonwealth can evaluate exclusions, just as they did the household exclusion. And if someone's to challenge an exclusion, if a carrier chooses to put an exclusion in, we look at it and say, does that comport with the goals and the purpose of the financial responsibility law? So therefore, in the Hall case, an exclusion for accidents out of the country, that's reasonable. We will enforce that exclusion. But what we have to understand is that the carriers have accepted premiums for this in the past. They have paid these in the past. This is put in merely to avoid paying claims. This is not a gratis coverage situation. This is a situation where I purchase coverage and the coverage follows me. Why should it matter if I am on a vehicle regularly used? Let's take an example before I yield the floor to Mr. Cooper. Let's take someone who is a prudent person. She insures herself, she insures her family. She buys underinsured motorist coverage. She's very protective of her family and her children. She walks the children to the school bus every day. She places the children on a school bus. As soon as those children step on the school bus, they are regularly using another vehicle that's not insured. As soon as they step on that school bus, they have no UM or UIM coverage. So this prudent woman who wants to protect her family loses that protection. It's not right. It shouldn't happen, and that's the impact of this exclusion.
Counsel, you definitively said UMI coverage is portable.
Yes.
Your learned opposing counsel said not true. Bernstein said it's not. Could you address that?
Well, I really have to commend...
Did Bernstein say that?
I don't think it said that. I don't think it does, Your Honor. And I really have to commend this court to the dissenting opinion of Chief Justice Emeritus Saylor, which gives he has a great history of the development. And that history, when this ties into your Gallagher question, that history is all about household exclusions. This exclusion is a relatively new exclusion that came onto the scene because it's an opportunity for us to save money and pay fewer claims. All exclusions, it's not the end of the world. All exclusions, this doesn't say, if you say this exclusion is invalid, and you say the mandate of 1731 and the portability of 1733 does not render every exclusion invalid. Each exclusion has to be evaluated on its own merits. Keep in mind what happens is carriers can choose to put exclusions in policies. They then say, well, since we have an exclusion, we are not accepting premiums for that loss. That's true. But because we're not paying those losses. But you do that at your own risk. They did that with the household exclusion. If I put an exclusion in a policy and I say because of that exclusion, historically I will not be accepting premiums for that risk because I'm not paying that risk. And premiums are based on payouts. Okay, well, in this situation though, they have been accepting premiums up to a certain point for that risk. They are complaining, well, since we didn't insure that risk, and since we didn't accept premiums for that risk, you can't impose that risk upon us. Not unlike the person who kills his parents and then complains that he's an orphan. They did it at their own risk, they chose it, they run the risk of that being inapplicable and void, and that's their problem. They created the problem. The insured didn't.
What I try to grapple with this whole thing is, what is the increased exposure? I mean, if you're driving your own vehicle and you're in a motor vehicle accident with an underinsured motorist, or you're driving someone else's vehicle and you're in an accident with an underinsured motorist? What is the increased risk?
I don't think there is any increased risk, Your Honor. That the risk is the risk of life. You know, it's the risk of it. I could be in anybody's car. They're saying, well, you're there regularly. You know, so therefore I shouldn't have it.
You said earlier that it is insuring against the negligence of others.
Yes.
What difference does it make what vehicle you're in under that
Exactly.
circumstance?
Exactly, Your Honor. That person could be a pedestrian. The regular use exclusion serves no real purpose. You know, if my son gets picked up every day by his buddy who drives him to high school, he is regularly using that vehicle. So even though I buy $300,000 of underinsured motorist coverage, when his friend picks him up and he gets in that car, he's using it and he's not covered.
It's personal injury insurance. It's not
Exactly, Your Honor.
property damage.
Exactly, Your Honor. So we, and I will yield the floor if I may to Mr. Cooper, but we respectfully request that the decision of the Superior Court be affirmed.
Thank you, Mr. Haggerty. Mr. Cooper,
Madam Chief Justice, members of the court,
you know a little bit about this subject.
I think I know more about SORNA at this point, but
There's a new line of business for you.
no. although if we lose, maybe a new form of business. This is the worst exclusion that could ever have been enforced. This, as Mr. Haggerty said, this was not in any policies until Justice Apollo's opinion in Burstein that was based purely on public policy. And retired Chief Justice Emeritus, and I always screw up that name, Emeritus, not Saylor, hit the nail on the head in his dissent with the portability and the whole history. This is mandatory offer. It's no more than contract law going back to Lucy versus Zamer in my contracts first year law school. Mandatory offer. They have to offer you underinsured motorist coverage. You either accept it or you reject it. End of story. If you accept it, then they have to give that to you. Section 1731D has limitations on recovery. What's an exclusion? It's a limitation on your ability to recover. If they wanted to put an exclusion in there, they could have. In 1990, they added about limited tort and full tort. What ended up happening here, in this case, if you go, they have in the statute, the legislature, 1714 has ineligible claimants. 1718 specifically says what may be excluded. Companies don't have to, but you know they're going to because they can. In this situation, it's a pure violation of the Act. And not every exclusion will be invalid. And it's just Judge Dubois and with Justice Bender and Justice Stevens in the Superior Court, it's arising out of the maintenance use of a motor vehicle. You're legally entitled to recover because it's the operation of a negligent driver, and you've purchased a UIM coverage. This is a safety net for you and your family.
Which ones would be okay? Which exclusions would be okay?
In a UIM? Well, you have the household exclusion with Mr. Mione. That would be allowed because we know that situation. And they would have to come forward and look at what exclusion they're putting in there. In this Erie policy, there's really only two exclusions in there. When we look at the policy, there's the household, which they've already lost on, and the regular use. There was a workers' compensation exclusion that's in there right now. That was already ruled invalid in A.L.R, but that was on public policy. There was, you have to give us consent. You have to get consent or you can't have the coverage. In Schneider versus Nationwide, Justice Saylor wrote, you don't necessarily need consent. You do it at your risk if they could show prejudice. These are exclusions that prohibit coverage from a safety net. And the Burstein case and the Williams case were all public policy opinions. And the Burstein case, and I think this is where train went off the rails and goes back to overarching dominant public policy. I pulled up the actual debate from 1990 that Senator Loper, actually when he was supported the bill, he said this is about cost containment to try to bring down rates but also preserve consumer protection. And that's exactly what happened here. It used to be mandatory rule. Now it's an offer and you accept it, so I get the coverage.
The cost containment was effectuated by doing away with the unlimited coverage of the No-Fault Act.
Correct, Madam Justice.
That's what
Donahue.
broke the bank.
That was the big, was the basic, you had unlimited medical bill coverage for forever. And that was where the problem was. And this was still giving, and that's why the exclusions never were enforced. And then the exclusions, the companies were able to use them. In this situation, Mr. Rush was like the appellants say, oh, well, you're going to hide your car and then you're going to go drive all these tractor trailers and everything. Yes, I'm going to go put my car in the garage and then drive a tractor trailer down Front Street all day or parallel park. But think about this situation. This only punishes people for working. This is a backdoor workers' comp exclusion to a certain extent, because anyone or almost everyone who's been hit with this exclusion is usually working at the time. No, I agree with you, Justice Doherty. It's him, but we're talking about the truck driver, or the ambulance worker, or the coroner, or to use an example, I think people would think I'm crazy, but the governor does not have coverage, Governor Shapiro, because he's using a work vehicle while he's being driven by his detail.
Have you advised him of that?
I guess if he watches PCN at 2 in the morning, Gov, sorry.
Are you prepared to speak to the opinion in Bernstein on this issue of portability and how it was resolved? Let me just share with you. My understanding of Bernstein is that the majority found it was not a portable coverage because of the cost containment overriding policies that were attendant to the motor vehicle responsibility law.
Yeah, Madam Justice Donahue, my understanding is it was purely an opinion based on cost containment, policy, public policy, that was the argument.
It could not be portable because that would go against the notion of cost containment.
Correct. But the cost containment was taken out of total context about unknown risk. First of all, the unknown risk is total bull. If you go, there are certain cases, Adamitis, and this is one of the cases I did before Jim got his angel and came to my side and everything. He was on the other side. We put in the record that Mr. Adamitis, on the application with Erie, was a BARTA bus driver. They knew he was a BARTA bus driver. On their application, they have occupation. They asked this question. They don't do the rating based on it, like Jim said. They do it based on the geography and things like that. If you take this whole case to its logical conclusion, as was stated, that as long as you pay for it, we could do any exclusion we want. Okay, now, if you live in Butler County, if you drive your vehicle regularly into Allegheny County, we're not going to cover you for underinsured motorist coverage because we didn't know you work in Allegheny County or Philadelphia County, because we're not going to accept that risk to drive in Allegheny County. That's really the type of exclusion they could do under this. And it doesn't protect people. You're buying a safety net. That's why, and this is only acting as a deductible in reality, because the priority of coverage, which was referenced in 1733, if multiple policies apply, in this case, if Officer Rush, he got $35,000. If his case was only $35,000, we're not here. If he had $100,000 and then he hits the $750, then it applies. But it's portable. It's going to him.
But doesn't that cut against the portability argument? the fact
little-
that in certain circumstances, you don't look to the coverage of the person who is the insured.
It depends on if you're under 1731 or 1733. Because if 1731 is portable, because it follows you, 1733 is where multiple policies would apply.
And the legislature gave the insured's insurer a break there and said,
Right, as the opposite of 1714 and 1713. So what happens is, in this case, if there was plenty of coverage on the, and keep in mind, these regular use vehicles, you have no notice that there's no UIM coverage. You have no option. Like, you can't go and say to FedEx, or like if you're getting driven around by a security detail, we want to make sure that you have underinsured motorist coverage, or I'm not driving that car and I'm not going to work. You're going to get fired.
Collective bargaining on it, couldn't it?
You can, only certain people, because you can't. The ambulance can't. The fire truck. I drove in this morning going down 83. I was paying attention, but I was kind of looking, and I'm like, almost 60% of the vehicles would be regularly used vehicles. You had a lawn care truck, this truck coming past Harrisburg Hospital. You had the handicap person. All these people are driving regularly used vehicles. And the other thing is, in this case, for Mr. Rush, let's say he's in his car, he's doing his job. He picks up a pedophile or a serial killer. Since we're talking about SORNA, I'll just go with the pedophile or whatever. They get hit by the negligent driver. They get the third party. Mr. Pervert gets the third party. They each get UIM on the township. Mr. Rush, take care, you get nothing. The pervert gets his own underinsured motorist coverage. That's an absurd result. Now, if it's a serial killer, you can make an argument that he's a serial, so he's regularly using the cop vehicle and everything like that. But this is the type of this exclusion, and that's why it came after the household exclusion. And if you actually go back to the Burstein decision, this regular use language was actually the household. It was morphed out from regular use. This could really, if you didn't have a household, the word household, you could say available for your regular use that's not on this policy, and it's the same exclusion. It would be a household vehicle. In fact, some companies are still trying to do that. In some of the cases that we're dealing with the household vehicle is saying, well, the term regular use is in there, so therefore it's the regular use exclusion. Well, like Jim, I say kind of nice. Jim goes, no, it's a household vehicle. So, but they're trying to use that. Yes. So, no, that's it violates the statute, and no one ever looked at the statute. Just like in sales, Gallagher, whether everyone agreed or not, the statute says you have to give people this. It's not for the insurance company to decide, all right, you paid for the coverage, we offered it to you, you accepted it, now we could decide to take it away. So we would request that the court be affirmed from the Superior Court.
Thank you. Mr. Shukanov, Mr. Haggerty, Mr. Cooper, this really should have qualified for CLE credit. It was something. Really tremendous arguments by all three of you.
Thank you. Very good. Thank you.
Clients were well served. Thank you. All right, thank you. Mr. Minner?